Page wise mentions, page number, item numbers 1 to 15.
15, 22, 22nd.
Page number 2, item number 16 to 23. Page number 3, item numbers 24 to 32. Page number 4, item numbers 33 to 47.
Item number 3010. Kindly have it after 2 weeks.
Okay. They want it on 22nd or 29th?
29.
29. 29 is working. Optional. 29.
Green optional.
Okay, 29th November.
Page number 5, item numbers 48 to
37.
48 to 57. Page number 6, item numbers 58 to 65. For orders, item number 1, 3
my lord.
out of 6 mentions today's Wednesday.
Then
Parimala Parigi, public prosecutor. Objections.
The CC copy is not available for not in that not online. So that's true. I haven't filed that. The CC copy of the trial court not filed, but criminal appeal I have filed the judgment from. The civil matters actually, yesterday they have listed 2 of them listed. It's talking about the people imprisonment which has to be run concurrently under section.
what is the objection?
That objection they have just posted it for your lordship's kind opinion. Criminal appeal, judgment, they have narrated the maps of the CC also. Every sessions judge has narrated the facts of trial court and maps. Judgment.
Okay, you have not filed a CC
Yes.
order, but you have filed the appeal order.
In appeal also, the contents were actually abstract was given, the CC's abstract was there.
And what about the memo of appearance to be filed, which is incomplete?
So I have filed it.
You have complied
Yes.
because the objections raised a complete memo of appearance to be filed and delay period to be mentioned. All that you have complied.
Yes. It's totally different.
Thank you for your application submitted. Thank you.
For admission, item number 2, Sri K. Pallavi, public prosecutor.
Or below found guilty of offense of reaction. Impose the fine check amount here. There are three cases and three check amounts here. Three checks here. One is also, one is 45 lakhs, and the third one is 15 lakhs minutes. Against the others of the report below, I have referred appeal again before the session judgment, before passing of the suspension order. But
Have you deposited 20%?
considering the amounts, reducing the amounts, I prefer this appeal revision.
No, because the appellate order is the 20%. Already suspended the, suspending the order, they have, should.
10% will be reduced to 10% of the amount of the fine.
How much is the check amount? How much is the check amount?
Three cases, madam. Three cases, one problem.
Three cases.
Yes, madam.
So what about this case?
First one, first 15 lakhs, madam.
Give me the other two. 11. Are the respondents different? Knowledge different?
Same respondent.
Okay, same respondent, but the checks are different.
Three checks, madam.
So total 1 crore 45 lakhs.
50 lakhs, madam. 1 crore, one check, madam. 45 lakhs is another check. 15 lakhs, another check.
So total
1 lakh 60, 1 crore 60 lakhs.
May I assist both with the written judgment of Supreme Court?
that's what is thinking, because she is respondent is the same person.
And my reason assisting the court with the written judgment of the Supreme Court.
What's the legal position?
20%.
Yes, I know about that.
No,
148. 20% of the amount has to be deposited.
no, not. They have given the exception power to the court that stating
They can dispense with it.
of the court if
It's not mandatory that 20%.
yes,
Somebody has given me the objection.
the seventh para is very clear before this court, in what the appellate court is considered the prayer of the one in the section 389 of CRPC accused who has a convicted under the 138 and Act is always open the appellate court to consider whether the exceptional case.
So what is the exception here? You'll have to make out.
That's what,
In exceptional cases, court has to record reasons.
that's what.
If you are dispensing with the that 20% of what is you have to make out. How is it exception?
Exception up to they supposed to come.
They're not in a position to say the facts only properly what they'll give.
Please consider the
What please? Only please consider I could hear properly. They're not in a position to say each check how much, total check, so much ambiguity.
also we will also get that can be very much.
The only thing is that the respondent is the same person. Three different cases are filed. Now, what about the third matter? The respondent, complainant is different. Criminal Act is 711. In 710 and the second item, same complaint. So how much is the check amount for the third case?
That's 2000 lakhs.
Third case.
Yes, sir.
What about the first case?
Yes. Lakhs 2000.
First case. Second?
Second is 1 crore 2 lakhs. 2000. 1 crore 2 lakhs.
So 45, first is 45.
Yes.
And somewhere 15 you were saying just now? First is 15. So 1 crore 15.
15 lakhs 2000.
So 1 crore 15. There the complainant is the same person. So in the third matter, the complainant is different. There I think it is 45.
Yes, sir.
They need to pay. Okay. Pass out. But I think I'll be completing my list quickly only. At 12:30, tell him to come. Next. 2, 4, and 5. Pass out.
Yes.
I'll take end of the list.
Item number 3, Barakavalla, Public Prosecutor.
Varka.
In discharge, we had filed discharge petition in CC number 2046.
What are the offenses?
The offences are at 448, 427, 506 to 506.
What is the allegation against the petition?
Allegation is trespassing and harassment, physically damaging and dismantling the property. This is the complaint given by the de facto complainant. A perusal of the handwritten complaint by the de facto complainant clearly shows that he has only mentioned trespassing, damaging and dismantling the property. But the fact remains, we had filed explanation to the 41A notice that was served upon me. In that, we have clearly mentioned that we had given written complaint to Town Planning Department, GHMC, to take action against the illegal construction which the de facto complainant was making towards the elevation of the building. And it was the Town Planning Department which asked them to pull it down after they visited the site. We were made accused because we made the written complaint to them. The exterior balcony side, they need not enter. It's on the first floor. They need not enter the premises to do anything like this. Trespassing, all these things, they need not do it. They can pull it out from outside itself. And it was not these two people, because one accused is 64 years old, the other accused is 62 years old. In fact, the de facto complainant is between 32 to 34 years old. He filed a police complaint against them. While this handwritten complaint does not speak of what actions have been done by us, it was improvised by the IO. And
So both of you are neighbors.
Yes, they are one floor above the already de facto complainant's flat. One floor, and the other brother lives on the other floor. There are two brothers. While we filed the discharge petition, we had filed the complaint copies along with photographs, everything to prove to just show the judge to take the
So you have made complaint about your neighbors to the municipality.
Yes. So meanwhile, in the counter, if you see the last page, of the material papers,
On which page?
the 29. The PP has written in the ending of the third paragraph, no documents should be received during discharge petition. When you have, the prosecution has suppressed my answer to 41A. And when in discharge petition, I am providing the court with the material. It's not I'm not asking the court to see the authenticity of the documents, but at least it gives a fair chance for me to express that I am not guilty about all these offenses. And meanwhile, this case was pending in the court. The de facto complainant has finished his illegal construction.
Yes, what is?
Lordship, page number 25 of the charge sheet. Clearly mentioned, while the investigation under progress 39/2022, LW1 issued 41 years CRPC 1 made to direct the public the photo, ID and proofs and complied with the direction and land. During the course of investigation, he elicited the LW1 is the owner of the plot number so Anand Vilas apartment in Maradpalli, whereas the accused persons A1 and A2 are also owners of plot number 201, 202 and 302, respectively. There are brothers also. The LW1 was carrying out of his plot works peacefully. The accused persons A1 and A2, who are residents plot number 201, 202 and 302, are intentionally threatening the workers with dire consequence and obstructing the work of LW1, and also the accused persons are intentionally trespassing into the flat and forcibly switch off the main switch of the flat and obstruct the work, and also accused persons have destroyed the work, which is done by the workers by threatening the rendered petitioner counsel already 41 year issued charges also framed thereafter that filing of the discharge petition. Discharge petition, page 9 of the page 9 paragraph. The learner urgent public prosecutor is counter file as well as supporting the arguments that in the present case nearly 6 witnesses are examined, and there were also 2 eyewitnesses and punches are also examined, which shows that there is a prima facie case, and also submitted the documents filed by the accused cannot be looked into the looked at the stage, and only after completion of the prosecution evidence they can file their evidence if they do prove the case under 315 of the Code of Criminal Procedure Code. Their defense evidence, but not at the stage of the discharge. The petitioner herein have filed the certain photos along with the discharge petition, and also stated that we consider in case WhatsApp group messages and also these photos. It can be stated that petitioner herein had not submitted the alleged offence, and they may discharge, but these documents also solely cannot be considered for deciding the discharge. The petitioner hearing because already investigation officer examined the several witnesses and particulars of case have recorded their statements, and it is recorded hence. They show that the prima facie case against the accused cannot be placed on the stage. Charge sheet also accused is groundless. So the set of circumstances it cannot be stated the allegations made against the accused are totally groundless. Accused discharge in present case because the present case is initial stage. Still the evidence is to be in both sides are conducting complete trial, but only guilty of the accused person.
Where are your complaint? Which you have furnished.
Complainant of the de facto complainant is submitted, but
Page
we
number
have
Where is the documents which you wanted to furnish?
we filed it in the lower court.
You are not filed.
Yes, because the PP had mentioned during the investigation, IO has examined L1, L2, and these documents cannot be received. So the court did not receive them. Meanwhile, page number 26, Your Honor, that is memo of evidence, list of LW1 to LW7 is there.
Yes.
LW1 is the complainant,
LW2 is eyewitness and worker of LW1. LW3 is eyewitness and worker of LW1 again. LW4 punch for CPL. LW5 is also punch for CPL. Then LW6 issued FIR. LW7 IO and punch. Where is the independent witness? Let the court for the records from the lower court, Your Honor, Your Honor, Lordship may see that the prosecution has not submitted anything that I have given to the investigating officer in my defense. And there has been a delay of 33 days in filing this complaint. The de facto complainant says my mother-in-law died, subsequently my father-in-law died, so I didn't do it.
So to the 41 a notice, you have submitted all this documents?
Yes, we have already done. And
And
stay may be granted, Your Honor.
The case, PC number 4046 of 20. It's on 29th December. Notice to respondent number 2. Take personal notice also is permitted through RPA. December 29th. They can take out notice to respondent.
4 and 5 are passed over. Item number 63, Katyayani Ram Shetty, Public Prosecutor.
Yes.
This criminal arson is filed against the order passed by the Honorable Metropolitan Sessions Judge by order dated 11th October 2020.
Yes.
Now this particular criminal MV was filed against the order dated 30/11/2008.
What is the grievance in the influent order?
Yes. And I'll quickly take me out to page number 22.
Yes.
And panel number 20. It clearly says that the record shows that the counter in this is against the DVC number 167 of 2012. Now this DVC was filed in 2010. There's a little bit of background which we need to appreciate because the matter is of 2010. And there are two cases there were two cases initiated by the husband against the wife and wife against the husband. Husband has initiated divorce proceedings against the wife before the Kukatpalli court, and the wife has initiated DVC proceedings against the husband. Now, while might wonder, but fact is that the divorce case is still pending before the Kukatpalli court because of the dilatory tactics of it. Now, why does she do this? Because she wants to maximize the benefits of the maintenance. Now, having said that, Millard, I'll bring my lord back to this point of DVC. Now, this DVC was dismissed in 2014 for non-prosecution, and this was order dated 6/2/2014.
DVC filed by wife.
Filed by the wife.
Wife was dismissed.
Yes,
Also.
yes.
Okay.
So after that, this is what the husband knows about the dismissal. Now, soon after that, she files on the same day of dismissal. She states that I was in the past, so I want to reopen, and files a reopen petition before the same court. And while this was going on, she abandons the proceedings in the lower court. She files a petition, she abandons the proceedings in the lower court, and files an appeal before the 8th AMSJ, challenging the order dated 6/2/2014. Now, husband is unaware of all these proceedings.
Okay.
From 2014 up until 2018, the notice is not served upon the husband. So an order came to be passed on 30/11/2018, granting maintenance of 75,000 rupees company, 20 lakhs compensation, and residence orders. Now, this is what has happened between the husband and wife. So the entire proceedings from 2014 up until 2018 were run clandestinely without the knowledge of the husband. Now, while all this was going on, husband came to know about these proceedings in October 2019. Now, after he came to know in the October 2019, he filed for certified copies, obtained them in December 2019. From December 2019 up until the pandemic, none of the councils were ready to take up the matter due to the lack of certified copies because it's a 2010 matter, and some copy or the other was missing. And the pandemic set in, and soon after the pandemic, with the 30-day delay, again the new council had to file certified copies.
Okay, take out notice. Because you are coming on condone delay.
Yes,
petition.
now the only submission is that they are pushing for execution of maintenance in the lower court to the tune of 75,000 from the year 2018. A stay may be granted on the execution.
But you are on condone delay petition.
Yes, because they have this dilatory tactics, and they need to. This is one way of bringing them through. I kindly request this court to.
No, but you need to take out a notice. This is you are coming on condone delay petition. It's not implementing any order.
They come on. Interest until they come on the court. Because they
Let them come.
they're pushing for execution. My humble submission.
Yes, you need to comply.
Yes, but what I'm saying
They are
is
pushing for execution. What is the use of passing your order
there is
of maintenance?
the only reason why I'm asking is because there is a lot of material that goes against the husband. None of the rights of the husband are all the rights of the husband are violated because he does not know, and this is to the tune of 75,000.
If he knows or not, he is bound to maintain his wife.
I mean, the quantum of maintenance is also a question. I just humbly pray before this honorable court just to state until they come on record, and then we will. I'm ready to contest, and there is no adoption of any dilatory tactics or negligence in this because 75,000
Maintenance orders are stayed.
Yes,
What is the use of passing the
1
order?
lakh rupees from the year 2010 is what they're claiming.
Yes,
I don't
need
think
to
the
pay.
bank is in a position to even afford this because this is
What is he doing?
he's a director. And he is a director software in a software company. He started earning 3.8 lakhs as net.
Take out notice to respondent. No, let them come. Notice to respond. Social.
See on the aspect because 1.55 crores is what they're pushing for.
List on 28.
Stay until they come on.
No, don't take it so casual. It's short.
Material on record is shown.
No, let them come on record.
Item number 7, Sri Madhavi.
28th November, take out personal notice. Yes, what do you say regarding the delay? 3,065 days. Is it right?
It's in the page
3,065 or 365? Because sometimes the mistake also.
Nothing mentioned the delay.
Delay, he is in the dialysis stage, my lord, he is bedridden.
Now, what is the reason for 8.5 years delay?
That's what, he is in the bedridden, my lord, in the dialysis stage. When he is failed, my lord,
Since 8 years?
no, multiple disorders.
No, you are mentioning some medical.
Submitted to 49 from the chart, 49.
Page 49. What is the order you are agreeing?
Admitted for 2 years, my lord.
What is the offense?
Offense is of forceful, my lord. 490, 464, 471, and 120. This is that, my lord, the petitioner who has purchased a property from the has later cancelled the same, my lord. Found
Now, what is the date of the sentence? Is it 16th March 2015?
that, my lord.
Now, where is he? Where is he? Out of jail or in jail?
He is out of jail, my lord. No arrest warrant is issued for him. That's what I have given.
NBW is very sure.
Yes. Maybe the record, the delay is concerned.
What about this condition on page 23? Awards which was ordered to be paid to the complainant.
Hey, the amount he complained to the session on this baby.
Just paid the amount while filing the appeal, I think. At the time of filing appeal.
Yes, ma'am. I did wait for me upon the criminal appeal. They wish us the hopefully appeal will be. Number 17 is a 2 months since that lacks by the next 4 years. From 2 years to 2 months.
Yes. What is it?
Contesting respondent is there, delay is the foundation system, and that's still defect to complaint is.
Issue notice to respondent. And person notice is submitted. Will list on 28th November.
Item number 8, C.K. Venumadhav, Public Prosecutor. Seven.
You said the arrest passed is there, number 130 of 2023. Additional Metropolitan Magistrate at Telangana. The CRLMP is filed by all these petitioners to discharge them. And CC number 484 of 2017. It initiated with getting on a complete file by the respondent number 2. Allegations of the respondent number 2 is that her marriage was performed with number 1 about 27 years back. Now making valid allegations, he initiated the proceedings under section 494, 498 A of IPC. There are no allegations against all these petitioners. But the married brothers,
Then what is their role?
nothing is there except bond allegations. There are no specific allegations.
Charge sheet is there.
Charge sheet is. Then they filed a discharge petition. The court below, without considering the grounds raised by the petitioner, the Lakshmi kindly simply expressed said discharge petition without assigning any valid reasons. Issued by the same and this reason is required. The court below, the Lakshmi kindly see page 19, para 6.6. No provision the court grants to the accused any right to file any material or document in the stage of framing of charge, and such right is granted only at the stage of the trial, and the court has to consider the police report and documents sent with it, but not a material produced by the accused. As stated above, there is prima facie material against the petitioners herein produced by the complainant police. To proceed with the trial, there is no force in contention of the petitioner, and however, no specific material also supplied by the petitioners to consider that the charge against the accused to be groundless, suspicion. At the initial stage of the framing of charge is sufficient to frame the charge, and in that event, it is not open to say that there is no sufficient ground for proceeding.
Okay, what does 239 say?
Discharge.
No, I know discharge. No.
That is discussed last.
There are
Not
no
that.
specific allegations.
Yeah, they're coming to conclusion is right or not.
Yes, yes, you cannot make identity. Whenever
Whether any documents placed by the accused can be taken into consideration or not. What is the legal position?
I placed the judgment of Honorable Apex Court, I didn't relay any document. At the stage of discharge, I cannot file any document, I cannot relay. That is the legal position. I didn't relay also. I only placed the citation that a recent Apex Court judgment, in which implicating all the family members who are married or who are residing in separate places with their
No, how can court come to a conclusion only based on the material placed?
based on the contents of the allegation, that's all. But there is my specific submission is that there is no such allegation.
No, but if accused says that he has no role,
But
how that should be considered?
unless there is a specific allegation that these are the
So that is a stage where they can be discharged also.
yes,
The court if there is no material.
that's what the discharge petition is filed. There is no such material placed by the
I mean, charge sheet.
yes, your Lordship, I list. Your Lordship.
I think page 32.
Investigation revealed that Evan is the husband of the victim, A2 is father. Case.
LW1 is the husband of the.
Yes, LW1 is the wife. A1 is the married husband. A2 is the father, but after filing this criminal case, he died. A3 is younger brother. A4 is elder brother. A5 to 7 are younger sisters, and A8 to 10 are brother-in-laws of A1 respectively. LW1 is daughter of maternal uncle of A1. Marriage of LW1 and A1 was solemnized about 27 years back at Ulmuntal Pahad village, Unnamallepalli Mandal, Nalgonda district, prior to FIR. At the time of marriage, as per the demand of the accused, her parents gave rupees 1,50,000, 100 tulas of gold, 4 cows, 20 tulas of gold, 8 sheep, 2.5 acres of agricultural land in Mallepalli were given and done. After the marriage, she joined the company of A1 at her matrimonial house at Kumbhakur village, which is a joint family, where they lived for 5 years. Her mother-in-law, Elama, died about 10 years back prior to FIR. A1 to A8 and Haraj had visited time to bring additional dowry from her parents, and Haraj had both mentally and physically, but she bore all the harassment silently. When they lived in a joint family, the accused took away her gold and cash given by her parents and purchased the land. Later, she was blessed with LWs 2 and 3. After the birth of their children, they started a separate family. Later, they shifted to Mallepalli, where they stayed for 4 years. At that time, LW9 arranged rupees 8 lakhs. The A1, who started a limestone and silver factory and latter in turn into losses. Latter A1 on the instigation of his brothers left for Hyderabad. Again A1 returned to Mallepalli and did LIC. Then she along with her children and A1 went to Timmapuram and did agriculture. However, again on instigation of his brothers and sisters, A1 left LW1 children and went to Hyderabad. Then she stayed at Timmapuram along with her children for 5 years. In spite of that, A1 did not return when she asked A2 to go to A1. He quarreled with LW1, went her. Moreover, A3 to A10 also joined hands with the A2 to harass her with words. They made her to leave the house. Owing to their unbearable harassment, LW1 along with her children migrated to Hyderabad and doing coolie work and nourishing her children. She made effort to face A1 but in vain. After she performed the marriage of LW2, for which she spent rupees 4 lakhs, she borrowed from different persons and the A1 or any of his relatives attend the marriage of LW2. LW1 telephoned to A2 to attend the marriage, but he refused it. He could not clear the above debts. He is doing coolie work and studying LW3. Without her consent or information, A1 transferred the land at Timmapur on his name. Despite she went to Timmapur, the accused was not showing her land. Moreover, she told her that he has no connection with the land. Despite informing the Sarpanch, was no use advice to take A1. A1 married LW13 and 3 years back. Considering his first marriage. LW13 has 2 children to A1. The A1 committed the offenses.
Most of the family story is written from the beginning to end.
27 years of marriage.
What is,
Lordship, page number 18 of the discharge petition, Lordship.
what is there
Para
in
6 and 4.
read it?
The warrant case of tribal magistrate in which is police report section 239 to party of the code of the relevant state law started process section 239 requesting magistrate consider the police report documents sent to the under section 173 and if necessary examine the accuser and after giving accuser an opportunity being heard the magistrate concern the charge sheet and accusatory grounds. The accuser liable to be discharged regarding reasons thereof. The further held that there is no provision in the code of grant the accuser any right if a file material document at this stage framing of the charge. That the right is granted only in the stage of the trial. The second paragraph, the perusal record complainant police filed a charge sheet and the petitioner accused number 1 and 10 alleging that the all petitioner in committed cruelty against the defective complainant by harassing her both physically and mentally. The further alleged that the accused only married LW3 Jilla is about the 3 years.
Okay, I'll pass out.
Charges are failure.
Charges frame.
Charge sheet already clear mentioned that entire house story.
Because this is discharge petition. Because it infractions if charges are framed. That's the reason. Consular petition. Respond number 2. Person notice also.
Item number 9. The Empati Mallikarjun Shastri, Public Prosecutor.
No, this is 130. Yes, please. And we did for 1 year.
Okay, how much is the check amount?
8 lakhs, please.
8 lakhs.
Relying upon this. Is now is working as a security guard at ATM center.
Pay 20% of the check amount.
Where the expenses he as he's working as a security guard for 18,000.
No, for what purpose has taken this amount?
This says long back, this is misused by check because what exactly I have updated before the court, lower trial court also. But I could not find this before.
No, but subject to payment of 20%.
At least it will be reduced the reduction on the list. Requesting that, not that.
Yeah, the order is to surrender. Did he surrender or?
No, because we have come before this court, that's what we.
To pay 15%.
10%. Because
Proper issue of the evidence, record, proper perspective and one or two. State is made what? Take out notice to respond. Sometimes they make state one and sometimes some make the state two. That's the reason I'm asking. Now here the state is two. So respond number 1, take out notice. A person notice is permitted. List on 29th December.
okay.
Subject to 10% of payment and 20,000 for surety.
Item number 10. The P. Bopanna, Public Prosecutor.
Revision is filed against an order. I think the petitioner is an accused.
Yes.
Prosecutor on the death of A1. This case arises out of the private complaint filed by the second respondent.
What is this? After the death of A1, adding the petitioner.
Petitioner as accused. But originally, charge sheet was filed by the police against 4 accused. A1 was prosecuted in individual capacity, but he was the managing director of Ramos Films.
Okay.
With the pendants of the trial below, he expired. Now the petition has been filed with the prosecution through and the petitioner, who is the
The
present
petitioner?
who is the present managing director.
Okay, in the capacity of managing director.
No, she's,
Because the earlier managing director has expired.
who was prosecuted in the capacity of an individual. Not as
Individual
a-
only, not as.
Now she sought to be added in his place, which is not permissible without any specific overtax against the petitioner. So if arise out of a private complaint filed by the second respondent, the police will after reference to the magistrate, filed a charge sheet for the offence under sections 406 and 420. But there were 4 accused. A1 was Mr. Rammohan Rao, who expired during the pendency of
Yes.
CC. A2 was a former employee from Ramoji Film City. A3 and A4 are agents.
Okay.
About the second respondent, A3 and A4 approached her on behalf of A2 for purchasing the plot owned by her. There was an agreement between them for 4,64,000. Then they refused to go ahead with the agreement of sale on the ground that it's government land. They returned only 2 lakhs. They did not return the balance. But according to her, this land has been occupied by the accused. And in the present chief affidavit, page 8. As far as A1 is concerned, there is only one allegation, which is at page number 10. For the first time, at the time of disturbing the land position, we went to the place, and from there we went to the Rammohan Rao, who is the MD of Ramoji Film City, and he forced us to sell our land. Ramoji Film City, but we denied and returned to our house. After 2 days, one Prabhakar Gaud and Buchi Gaud came to our house and threatened us to sell our land to Ramoji Film City and settle the matter.
Who is this Prabhakar? A3 and A4?
A3 and A4. Out of A3 and A4, A4 also expired. Only A3 is left. A1 died, A2 died, A4 died. A3 is alone is there. Left to face the trial. After 2 days, one Prabhakar Gaud and Buchi Reddy came to our house and threatened us to sell our land to Ramoji Film City and settle the matter. With Govind Rao, and said Govind Rao sent to be Rammohan. That is the only allegation. In fact, the second respondent filed a land grabbing case that was dismissed. Now, in the petition below, they try to say this is a prosecution in a representative capacity against Mr. Rammohan Rao, which is not correct. Kindly see page 15. With the typed copy below, I filed you. They filed a handwritten copy. In the above case, the case was registered against A1 and others, where during pursuance of the case, A1, who is the managing director, has died, and the offence done by A1 in the capacity of MD of Ramoji Film City, which is not correct. And the fact of involvement of A1 as MD of Ramoji Film City has been explained as a victim. There is no such explanation given by her. Further, it is submitted that A1 died as per record. Film City, for which accused represented in the capacity of MD, is in existence, and the present MD is answerable, liable to represent on behalf of Ramoji as it's a juristic person. Further, unless the MD arraigned as accused, the defect complaint will not get justice, and the prosecution intend to do justice, and the victim will be futile. As such, it is just to call and present MD as accused on record in place of deceased accused. In place of deceased accused. Otherwise, now the magistrate has not given any reasons. Kindly see page 7. Petition is filed by ABP under section 390 CRPC to arraign the present MD of Ramoji Film City in place of A1. Not learned words. So after perusal of the petition, Chief of PWO, because this court is satisfied with the reasons mentioned in the petition. What are those reasons? How petitioner is responsible? Nothing is explained. The 390 is very specific, but there must be evidence.
Yes, yes.
No overtax. She became managing director in 2022. Period of 5 years.
Okay, the present person.
Filed the return filed before the registrar of companies.
And this incident took place?
99.
99.
99. Land grabbing case was filed in the year 2009. It was dismissed by order dated 30th March 2012.
And the allegation against A1 was in the personal capacity.
In the personal
Not
capacity,
on behalf of.
it was a representative prosecution. The company should have been implicated. Company has not been shown as an accused. By name he was prosecuted.
Company has nothing to do.
Yes.
And
Clearly,
including.
he filed a discharge petition that was dismissed. Second, that he came and reviewed to this honorable court. This honorable court stayed the process further proceedings in the CC. He expired during the pendency of criminals.
Now, what are his IS?
But there are 2 IAs. One is for suspension of the improved order. The other IA is for stay of further proceedings.
And I'll shall allow this IA, take out notice to de facto complaint. And we will list it on December 29. IA 1. Suspend the operation of the docket order dated 26/10/2023. Before the magistrate A1. Now, like your submissions, and now I'm pleading petitioner / accused number 5 without any reasons and material place.
Item number 11,
Yes, next.
item number 11, C. Sharon Reddy, Public Prosecutor.
Even sir A1 to A3 were convicted for the offence under 228 IPC, but sentenced to amount of 1,000 rupees only.
What offense is that?
228 million, that is obstructing a public servant for holding an inquiry. And when an inquiry was going on in the company, A1 to A3 raised Galatas. Because they are convicted under 228 sentenced to pay a fine of rupees 1,000 by the third magistrate. They filed an appeal, fine amount was paid. In the appeal was dismissed. By dismissing the appeal, the court below directed them to surrender before the court, and if they do not surrender, directed the trial court to issue non-bailable warrants. There is no sentence of imprisonment imposed upon. The Lordship carries the sentence. Page number 12 is the judgment of the trial. Sentence is at page number 22.
Page number
22. In the result, considering nature of offence and other circumstances, A1 to A3 are convicted under section 255 CRPC or the offence under section 228 IPC and the sentence will be fine of 1,000 rupees for each of these except for 1 month.
There is no sentence.
There is no sentence. Well, Lordship may kindly see the judgment of the appellate court. Page number 4.
Page number?
Page number 4 of the relevant portion. The page number 10. Paragraph 15. In view of this finding from point 1 and 2, I hold that the prosecution has successfully established the guilt of the accused for charge under 228 and trial court did not commit any element convicting the accused for the opposite charge and not find the finding. The result similarly is confirming the judgment terms. 17th paragraph. A1 to A3 are absent today, so they are directed to surrender before the learned trial court on or before 24 and 25. And on such surrender, the learned trial court shall commit them to prison to serve the sentence of imposed. If the A1 to A3 fail to surrender on or before 23 and 2000, the learned trial court shall secure their presence by issuing a non-verbal order and commit them to prison to serve the sentence of imposed. The fine amount has been paid, there are 5 receipts at page
No, no, okay. If he was not present, issuing NBWs is a different aspect. But the first sentence is not proper. The trial court shall commit them to prison to serve the sentence of imprisonment. This is not proper.
Yes.
If the appellant so and so fails to surrender on so and so, the trial court shall secure the presence by issuing a non-bailable.
Once the fine amount has been paid, apart from convicting them, for executing the sentence. If they are not paid the fine amount,
So at the time of filing appeal itself, they are paid.
If the fine is paid, Lordship may kindly see the date on the fine receipt. Page number 24 are the receipts of the three. The fine amount was paid on 8th.
So once 1,000 rupees is paid, there ends the matter.
They are challenging the conviction, because it becomes the way of employment and other things.
Okay, so they have filed appeal only challenging the conviction at the time of filing appeal.
Conviction and sentence. If they succeed, 1,000 rupees will be returned.
Okay.
But I filed IM, signature of paragraph number 17.
Yes, sir. Please to suspend operation of paragraph 20 of the appeal court. Okay. Yes.
Page number 13 of the judgment copy.
What is there in page 2?
Yes. Now the parliament to note the evidence for these witnesses. PW1 shows that the working as social security office and power and fund office when he was on duty. The commissioner was doing the inquiry since the output.
No, that is not the issue here. Is not going into merits of the case. Only sentence.
Yes, that's the fine amount already paid.
Yes, sir. No imprisonment was
Yes,
there.
sir.
Only fine was there. But appellate court has imposed like surrender and they should undergo.
Nature is outside in the jail. Actually, it's not surrendered on that time.
No, it's not that. Lower court has given only 1,000. So appeal was filed paying that 1,000 and he was questioning the conviction and the sentence. Might be he was not present, but might be just typical mistake or routinely they have passed that whatever without looking into the lower court orders. Also. IA 1 of 2026 filed to suspend the operation of the paragraph 17 of the judgment.
Item number 12C, SR Sanjeev Kumar, Public Prosecutor.
Both the similar matters.
It's a reference to 138.
Both the matters are 138. Who is the complainant? Both are same.
Common, accused is also common.
Then why two cases? Two different judges.
Two different texts, two different complaints. High Court and the appellate court. But the appellate court modified the judgment imposed by the trial.
Yes.
Can kindly take up page 28, the operating portion of the judgment passed by the magistrate court. The result accused is found guilty of the offence under section 138 of NIR accordingly is convicted. Considering the facts circumstances of the case, nature of the offence, accused is convicted and sentenced to undergo rigorous imprisonment for 1 year and fine of rupees 5,000 each. In default, simple imprisonment for 3 months for the offence under one. Then thereafter, Lordship, the petitioner paid the fine amount that is in page 29. Fine amount was paid before the magistrate court, their appeal was filed. Lordship, in this case, during the pendency of the case before the magistrate court, the entire amount was paid. Lordship may come to para 30 of the appellate court judgment, para 90. Page 19, para 30.
Page 19.
Page 19, para 30. This is what the magistrate court debated before. Admittedly,
Yes.
the payment under the dishonor check was already made on behalf of the accused to the complainant through other legal process. There was a summary suit being filed before the civil court and the payment was received. The document as realized by the accused in exhibit D1 to D3 shows that amount was realized by the complainant by taking a check from the competent civil court on 4/1/2017, long back to the passing of the judgment by the trial court. Here the magistrate court has heard and taken into consideration of this. Prior to the commencement of the trial before the magistrate court, the total amount was paid. Not only total amount, double the amount of the check was paid, 32 lakhs. The amount is about 20 lakhs in both the complaints and 32 lakhs was paid. In the subsequent page 20, complainant was cross-examined on 27/1/2017 and the check was issued by the competent court to the complainant much prior to the date, that is on 4/1/2017. Surprisingly, there is no whisper in the entire evidence of PW1 showing about receiving of the amounts by him from the competent court.
So that was the reason for modification.
I'll come to that. Para number 32.
Because that, okay, read.
Now here the total amount is paid, but still is convicted.
Yes, yes.
The trial court has convicted, para number 32, madam.
Yes, yes.
The trial court has convicted the accused under section 255(2) of CRPC and sentenced him to suffer rigorous imprisonment for a period of 1 year and to pay a fine of 5,000 and default of payment of fine to suffer simple imprisonment for a period of 3 months, as seen from exhibit B3 on the record. So, your lordship, the operative portion of the judgment.
No, but the findings was already paid to the complainant, though not by the accused directly, but other legal process.
Other legal process, civil suit, arises of the same transaction. That is what my submission is before the court. Amount, the two checks pertain to 10 lakh each. Amount was paid by the complainant before the commencement of the trial before the magistrate court. That has been observed in para 30. And neither the complainant counsel nor the accused counsel brought to the record of the court before the trial. Now, subsequently, the operative portion of the judgment is the appeal is partly allowed. The judgment of conviction the accused filed in CC 226 of 15 on the file of 25th Special Magistrate Hyderabad for offence under section 138 is upheld. However, the sentence part is modified and is reduced to 3 years. To simple imprisonment. So already the amount is paid in the year 2017 itself. We are in 23, and the appellate court ought to have considered my appeal and allowed the appeal in part by
allowing the payment of fine of 5,000 because no compensation was granted by the magistrate court. Why? Because already the entire amount was received, more than the amount,
So now only 3 months, I think.
3 months. So I'm seeking suspension of the sentence because it's not behind bars.
It is not been.
For that reason only, even they are not deposing the process. The complainant, that is the procedure laid out. Once there is a conviction held by the appellate court, the complainant ought to deposit the process before the magistrate court in order to execute the same. Here the complainant is not coming forward, is asking more filage from me so that I can compromise before this court.
Because of this order.
32 lakhs were not paid to the complainant for 20 lakhs. At the time of transaction, 3 lakhs was already paid. That was admitted by PW1.
Okay,
raised that
and
contention
suspend
by-
and let him be released on the subject to 10,000
Already
cases.
20,000 two sureties were filed before the court below. That is magistrate court when the appeal was filed. On the same sureties.
Yeah, that's good. Yeah, 1/2026 filed to suspend the sentence passed in criminal appeal number 440 of 2018.
ఈరోజు లిస్ట్ లో కొన్ని మ్యాటర్స్ 2:30కి వచ్చాను అంటే పాతవే క్యారీ అవుట్ అయింది ఈ మ్యాటర్ ఈరోజు స్క్రీనింగ్ లో పెట్టమంటే పెడతాను సీరియల్ లో పిలుస్తాను
ఓకే.
ఇవన్నీ
అంటే ఇంతకుముందు అట్లా వచ్చినాయా?
అంటే పాత దాంట్లో ఆ కోర్టులో వచ్చింది అదే క్యారీ అవుతుంది 26 2:30 అని వచ్చింది ఐటమ్ నెంబర్ 26 Okay, for,
So will be called
as per seriatim.
seriatim.
Yes.
Seriatim in the list. Next.
Admission matters, item number 14, Sri Kondapalli Shyam Sundar, Sri Kiran Palakurti. Provision staff. ROs installed. Additional documents.
Yes.
I am the petitioner. Petitioner is the wife here. In the court below also petitioner is the wife below. The case of No.22 CRPC maintenance case, wife was denied the maintenance on the ground of woman. She left voluntarily from the matrimonial alliance. It's only the ground to deny the court.
You're ready?
I'm going to respond.
Yes, you're ready. I'm asking.
Yes, ma'am.
Page number 9.
Page number?
9. The last one.
Silent. Can underline just in whatever. Page 9.
Bottom to 7th line. This is the
Para 11, 7th line.
this one. Bottom to 7th. Bottom to 7th.
From bottom.
This part of evidence is very clear that the petitioner is not willing to join with the respondent. If the respondent resides other than Balapeta, that itself shows that the petitioner voluntarily left the company of the respondent. As such, petitioner is not entitled to claim any maintenance from the respondent. The petitioner failed to prove that he was totally neglected and refused to maintain by the respondent. As such, the petitioner is not entitled to claim maintenance from the respondent. The petitioner is not. The evidence of the petitioner and the evidence to which my case will have. The evidence of the allegations are moral. The
Yes, yes. Make.
the cases already filed against 494 IPC against the husband mother at page number 4 or page number 7 of the petition. The first top para number 7 there. That is the middle of the page number 7. In the month of October 2014, the respondent left the house to attend works, but he did not return back. The petitioner came to know that the respondent contracted second marriage. On 23/6/15, the petitioner along with her parents went to Kodakondla village and found the respondent along with the woman by name Ujwala. On that, the petitioner gave a police complaint in crime number 28 of 2015 and section 498A and 494 IPC. As the respondent totally refused and neglected to maintain the petitioner, and as the petitioner is not having independent source of income, the petitioner filed this petition. That is the main root cause. And another thing is the allegation is against wife is she is not residing at her matrimonial house and she wants to shift the residence from her parents' house. So accordingly, the wife and husband shifted to the parents' house of the petitioner. Sometime they live sometime there only at the parents' house.
Just now you read something. From which page you read?
That is page number 7.
Para?
Internal page 4.
Para number?
First para. Page number 4. Middle of the para.
Yes.
On that, in the month of October 2014, the respondent left the house to attend works, but he did not return back. The petitioner came to know that the respondent contracted second marriage. On 23/6/2015, the petitioner, along with the husband, went to Kodakonda village and found the respondent along with one woman by name Ujjwala. The petitioner gave police complaint in crime number 1 under section.
What happened to that case? 498.
Target is not.
Not valid. 2015 case.
So, Millard, the
Follow. What do you say?
My lord, 125 clause 4 clearly says, my lord, permit me to read the 125 clause 4 of the TSHC, my lord. No wife shall be entitled to receive an allowance from the husband under this section if she is living in adultery, or if without any sufficient reason she refused to live with her husband, or if they are living separately by mutual consent. Here in our case, she refused to live with her husband and she voluntarily, without any reasonable cause, she left the
Now, what
company.
is the sentence there? If they reside separately
or
reside separately with mutual understanding.
mutual.
So where is the evidence to show that with mutual consent she was living separately?
No, my lord. My lord, I'll again read it. No wife shall be entitled to receive an allowance from her husband under this section if she is living in adultery, or if without any sufficient reason she refused to live with her husband, or if they are living separately by mutual consent. Divorce.
So what is your contention?
She left the company of the husband.
Second point.
Yes, sir. Yes, ma'am.
What is the evidence to show that she left voluntarily?
She only disclosed, my lord, in PW1 cross examination, in additional material paper, page 3, my lord.
Page 3, additional material. Evidence of
PW1, my lord. 13th line.
13th line. Cross examination.
Yes, ma'am. Cross examination of PW1. It is true, myself and respondent came to Balapeta and resided in the rented house. A panchayat was held at Balapeta about 2 or 3 years back. Myself and respondent were stayed in Balapeta in the year 2005. At Balapeta, the respondent took rented house consisting of one room. The said rented house is located after 5 houses from my parents' house. Thereafter, she did not used to take care of the respondent.
Where is that?
The said rented house is located. I have not filed any case against the respondent at Torur. Panchayat was held as the respondent harassed me by consuming alcohol. I can produce the documents relating to the panchayat held by the Balapet. My lordship, in the judgment of the Honorable Trial Court, also in the paragraph 11, it has been clearly stated that she refused to live with her.
Show me here where she said she left to be on her own. Oh, she voluntarily left the company of her husband.
Twelfth from the bottom line. 12th. It is true my father got constructed another house. At the present, my brother is residing in that said house. It is true that said house was constructed in my name. It is not true to suggest that the respondent and his family members attended the house opening ceremony. Then said that the said house was not opened by conducting function. It is not true to suggest that on the date of function, my brother met the respondent. My father is having 2 acres of land situated at Tekupalli. It is not to suggest that my father promised to allot share to me in the said agriculture land. It is not to suggest that as my brother met the respondent from that day onward, that is since 2010, I am residing with my parents. Not filed any police case against the respondent. But this is only the allegations, my lord. The allegations against the respondent they filed, my lord. My lord, and in her evidence in the next page, my lord, she used to follow the Baptist, my lord, Christianity.
So So what if she's following some relation?
Section 24 of the Hindu Adoption and Maintenance Act, my lord. Section 24.
No, you said she voluntarily left the
That
company.
is one wrong, my lord.
No, but where is it? You're reading the entire evidence, but where is that she voluntarily left?
My lord, next page, my lord. Page number 2.
According to you, if she has voluntarily left his company, she's not entitled.
It's not entitled.
You have to establish.
Same has been exposed in trial court also stated the same in the paragraph 11, my lord.
Don't go to what trial court said. Where is your evidence? Based on your evidence, court will say something. If without your evidence, court says something, you have to set aside that.
Yes, my lord.
That is the power of the revision here.
Yes.
That is the reason he is in revision.
My lord, it is true to say that page 2, my lord.
Page 2.
Last.
Read.
It is true my maternal uncle used to visit the church. It is true that I also used to visit the church oftenly for the prayers. It is true I am follower of Christianity. I have not taken baptism so far. It is not true to suggest that since from year 2010 I am residing away from the respondent. Since then I am filing the false case against the respondent only to harass him. It is not true to suggest that I am.
What is that? Just read it again. From when she is recent.
It is true that maternal uncle used to visit the church. It is not. It is true that I also used to visit the church oftenly for prayers. It is true I am the follower of the Christianity. I have not taken baptism so far. It is not true to suggest that since from the year 2010 I am residing away from the respondent.
What does that mean?
But this is the bald allegation, my lord. She just deposed it falsely, my lord.
She's saying it's not true to. It is not true to suggest that since from the year 2010 I am residing away from the respondent.
But no,
It shows she is. The allegation which you are making is false, she says.
she filed all the cases, but that no charges has been filed.
Shall I take it as heard?
Will file relevant judgments, my lord. Kindly post it on Monday.
You have not shown me a single sentence to show that she is residing away on her own. I mean, voluntary, she is residing alone. So, that to sustain the lower court order.
Post it on Monday, my lord. To satisfy your lordship. I'll satisfy your lordship.
Respondent not ruling that as the
And there is no dispute that she is the first wife. Okay, request of respondent counsel. 14 item. You are representing Kiran Palakut.
Yes.
What's your name?
NRP.
Narthi, representing Kiran Palakut. 6 time. At request. When should I list?
Monday.
Monday. Monday is a holiday. 14th.
14th.
only for submission of the cases.
Only for citation.
Citations, and I'll satisfy your lordship regarding that she voluntarily left the company of the respondent.
You can also take judgment without any. Shall I give 14 or 21st? You can better. We'll dispose on that. 21st November. You to see some judgment in your favor.
Only point is that she, if they are doing that, their contestants, she voluntarily, there is no evidence. The respondent.
No, but you have to place, you have to satisfy the lower court order and allow your revision.
Yes.
Item number 15 is adjourned. Page number 2. Number 16, Sri Chakra Srikanth, Public Prosecutor.
24. List on 28th now.
Item number 17 to 20 are connected matters, my lord. Sri A.P. Reddy, Public Prosecutor.
Not presentation, 28/11.
Item number 21, Sri Bandi Varaprasad Rao, Public Prosecutor, C.K. Lakshman Rao.
No representation. List on 29.
Item number 22, Sri H. Sudhakar Rao, Public Prosecutor.
No representation. Is represented. No representation for petitioners. List on December 7th.
Item numbers 23 and 24 are connected matters, my lord. Party in person, Mrs. Eunice.
23 and 24.
24 connected.
ఇవి ఇంటికి వంటకం స్టార్ట్ చేస్తే
Interim orders suspension case. Written submissions file చేయాలని దీంట్లో interim orders ఉన్నారు. Interim orders సార్ written submissions వేయలేదు. Delay from the motion.
మూడో విషయం
Delay. ఇది కాదు. ఒకటి కాదు. ఒకటి పోయింది.
The delay content petition is pending.
You relationship and filing a petition for extension of stay. The stay is extended after this honorable court passed the last stay. Subsequently, this honorable court was on during that time the in-charge court has directed that the stay be extended. I had filed my lordship, and subsequently the matter was again not listed. The stay may be extended, my lordship, because the lower court, the trial court is proceeding with the stay, with the trial.
You are representing this.
And the requesting of the point, because time of 1 week.
1 week.
Yes.
My lordship, the stage is coming up for arguments for a very long time. So, in fact, that is the stage of the case right now. This case is pending in 2020, my lordship, a revision in the DVC matter, which is vital for sustenance and for residence.
Okay. What is the stage in the lower court?
The stage, my lord, in the lower court is for my appearance, my lordship.
Okay.
Merely for the fact that due to the non-listing of the matter, that the stay has not been extended, the lower court is proceeding with the trial and planning to dismiss the case, my lordship. There is no merit, there is no chance of survival of the case at all in the trial court, because the respondent has never appeared even once during the entire trial, which took place over 3 years, my lordship. It was filed in 2000.
So if this stay is not extended, they may proceed with the trial court.
Yes, my lordship, they are proceeding with the trial and intending to dismiss it. Though I have stated before, I have appeared before the trial court and informed the trial court that the stay extension for stay has been granted. Is being filed, it is already being, stay has been given in extended price. Therefore, my lordship, the stay will be extended until further orders. So that every time we don't have to file that extension stay, and every time, because there is no chance at all for the in-charge court, my lordship, has passed orders hurriedly within 5 days. Within 5 days, my lord, the in-charge court hearing the DVC appeal has immediately understood the case, listed the matter on a day-to-day basis, and disposed the matter. He has not even heard me, he has refused to hear me, and he is giving a wrong docket orders that I have not represented, that I have done this. This kind of personal remarks he has made. So therefore, my lordship, as far as the conduct of the lower court is concerned, it is very much questionable in that the in-charge court who has read the office of the regular presiding officer has disposed the matter within 5 days.
No, but I think last occasion you answered, because before it was before other bench, you have sought, for written submissions in the revision.
Yes, my lordship. I have sought for written submission because the lower court, my lordship, had refused to submit the bundle in spite of repeated instructions. Since then, my lordship, 3 more notifications have been sent by the registrar judicial directing the lower court to finally send the documents, call for the records.
My lordship, a call for the records was issued by court number 10 in March, my lordship, of March of 2021. Since 2023, we are still waiting for them, my lordship. They are giving it in gradations. When the first original order was given to the lower court to submit the entire records, she has submitted only 3 records, my lordship, saying that this is sufficient for the High Court. She said the judgment order, appeal filed by me and appeal filed by the husband is sufficient. Again, another letter was sent through the registry directing them to send absolute full bundle. Again, they sent only 2 more documents. This has been going on since 1 year. I am constrained because what happened, my lordship, is that in the trial court, when we file the petitions, we are not given the SR number, we are not given any number. We just file it before the bench. Before 12 o'clock, we have to file it before the trial court. Then later, we have to go to the section and get the SR number. So I am not able to mention the case numbers in my appeal. That is my disadvantage. But now, my lordship, the situation has come to such a stage that for 2 years, I have gone to the lower court, my lordship. Even last week, again, I have addressed a letter to the sessions judge asking me to at least examine, inspect the records. That is not being allowed. The case was disposed in 2020. I have gone to the record section. She has still not sent it to the record section in spite of the case being disposed in 3 years. When I file a petition asking her to allow me to inspect the records as an officer of the court, she has returned it saying not required. When I file a CA, they are saying until you give the SR number, how do we comply with the certified copy? So now I just have to argue the matter saying that I filed a case for which I don't have the number. That is making my argument look very weak. Therefore, my lordship, since 3 years have lapsed in this calling for the records, I don't have any case numbers because I have only filed a petition before the court. The respondents have also filed a petition before the court. SR numbers are not given to us. We have to go to the section to get the SR. They are not giving the SR number, and the court is disposing the case without my even being aware of the MP number, SR number. Even to file a certified copy, I have to get a SR number. Otherwise, they are not compliant. So I have filed a memo. Memo is rejected. Then I filed another application seeking. Last week, I have filed before the sessions judge saying that I might be allowed to inspect the records. And at least the 9th sessions judge might be directed to send the to the record room because it has been 3 years since it has been disposed. However, the staff tell me that she has locked it up in her cupboard. What is this, my lord? So now I am left to only argue the matter on the points of the order without relying on the.
Okay, I will extend the stay granted.
The last chance at the.
What?
Last chance at the 1 week time.
My lordship, but anyhow, I'm ready because even otherwise they don't have any case. Point number 1, he says is that he has dismissed my revision on only 2 grounds, saying that the domestic incident report has not been filed. On the other hand, the Supreme Court has stated that the domestic incident report is not at all mandatory. And the other point he has said is that her father has said that she is not a good person. So that is also not relevant. So based on these 2 grounds and the fact that he thinks that
Okay,
I
we'll
am
see.
a good person, on these 3 grounds he has dismissed. So I am ready to argue the matter because there is no chance of my getting the record now after 3 years.
Okay.
So on the points of the order itself, I'll have to argue the matter. My lord,
I'll extend this stay.
short date may be given, my lordship, because at this rate, I'm never going to get the order copies. 5 more letters have been sent to the.
It may take some time, then you need to get all the order copies, everything. We'll hear the matter finally, but I will. Now, meanwhile, I'll extend so that you.
To argue the matter without the documents, I am going to argue the matter now.
Stay, your proceedings will be stalled in the court below. However, no prejudice will be caused. Yes,
Not till next date, because every time I have to file application.
Stay granted on which date only? Let's verify on which date it was granted. Have you mentioned in your application?
25/8.
25/8.
Yes, ma'am.
Short date may be given, my lady. I just argue on the order itself because now that I don't have the documents, I have given up on the documents, my ladyship. 3 years have gone. I'll argue without those documents, such as GPA being given by an unknown person, condone delay being filed without any copy being issued to me. Nothing has been done as per procedures, my lordship.
Yes, extended until further orders.
Yes, sir. Short date may be given, my lordship.
Specific of the application is counted until further orders the stay is granted, and I'll list it on December 12th.
But also a shorter date may be given because I have to go to. I have a small matter there.
No, no.
November itself, my lordship, because I want to finish the case now. We are-
My vote is full in November. However, I have given until further orders. So no
My lordship,
prejudice.
we need relief because there is no chance of the, he has even admitted that he has not paid the amount. When he has not paid the amount, the Supreme Court has.
No, but however, now we are having the immunity because until further orders means you have to court, the proceedings will not be proceeded in the court below.
Yes, my lordship.
We
but
have
I
no
don't-
threat of that.
I have not been getting any update.
Understand your reply. That is the reason I given until further orders.
Yes, my
We'll
lordship.
see later.
Short date maybe.
December 12th, you are not here.
My lord, December, my lordship, actually I have to, there is the Diwali vacations are coming up. I have-
That is the reason I'm not giving in November. You should understand before you say
Yes,
specifying
my
it.
lord. In December, I have some couple of SLPs before the Supreme Court.
Shall I give January then? Because we are aware, we need to hear it finally. You are having the extended until further orders. No threat now.
Yes, my lord.
So in January, shall I give?
November, my lordship, because November I am here.
November, you know, it's a Diwali time.
First week of December.
December, okay, 12th is okay.
All right, my lordship.
Item number
If
25.
you are having any problem, I can give some other date later. We'll see.
No, no, my lordship, as soon as possible.
December 12th.
Item
Madam, item number 17 to 20, Madam sir. I'm sorry, Madam sir.
What is it?
Item number 17 to 20, Madam sir. My matters.
No representation. I have adjourned to 28/11.
Madam sir,
Item number
technical
25.
difficulty.
Bajrang Singh Thakur,
We have already completed 23, 24. Now we are mentioning about.
Public Prosecutor Sri Mohammed Azmal Ahmed. Some of the respondents.
And some of it's already left, I think.
May I please, my lord? I'm appearing for the respondent, my lord.
Dismissal of protest petition, vision being filed, madam.
He is representing the respondent.
No, in my case, he is defending.
In your case, okay. Who is representing respondent? In your case?
Azmal Ahmad.
Where is it?
Only 2 to 18, but some of the respondents.
Okay, some of the respondents notice is not served.
The contesting respondents are there.
Other respondents are not necessary. This phone number.
Order for dismissal of protest petition, madam. It's reason being filed, madam. The facts of the case are
I think I have to hear respond number 2.
Yes, advocate is there, madam.
Where is, who is it? That's what I was asking you just now.
25,
Who is
Sri
representing?
Mohammed Azmal Ahmed. Item number 25.
May I please, my lord? I beg to represent Ajmal Ahmad, my lord.
You are representing respond number 2. Are you ready?
Requesting time, my lord. Requesting 2 weeks time, my lord.
Just be ready. It's a protest petition.
Next week.
When do you?
Obliged.
Which date? Which date I should give?
Next week.
14th or the 21st? 21st.
Obliged.
Item number 26, Sri T. Rajnikant Reddy, Sri T. L. Nayan Kumar.
May I please, madam? Is it 2:30 can ask?
Is it, no?
Wait, this is a case where the petitioner is a MP. So the roster is with
15th.
yes, former legislators and legislators. The roster is with 15.
Lord, in fact, it appears, my lord, on note of Chief Justice, my lord, this matter has been allotted to your lordships, my lord. But anyhow, my lord, the another case, my lord, same crime, my lord, there is a step before the Honorable Apex Court. That matter is coming up on 4/12, my lord. After 4/12, lordship may post any date, my lord.
Earlier, my lord, earlier occasion chief note was there. But the matter was used to be allocated to.
No notice there. No notice there in this case.
My lords, causalist it appears, my lord, not aware.
But the matter used to be come up before his lordship Justice Semi Makta. So, my lord, he is, my lord, the maternal uncle filed wakalat, so that the matter went to some other judge. At that time, my lord, the.
Okay, not before, I think, in that matter.
In that matter.
Okay, but however, now this will go before the court having their
Yes.
provision.
Yes.
Yes.
Please still direct it. Shall I say,
Well, they want after fourth, my lord, actually matter has to be listed before his lordship Justice K. Lakshman. My lord, he's having the roster, my lord. The learned judge is having roster.
shall I say wrongly listed or shall I say with the directions of the Honorable Chief Justice? Better.
Now the roster is there, my lord.
Yes,
There's no
roster is there,
necessary-
that's but it's listed before.
Yes, your lordship can say that, my lord, the roster is with
Post, before the regular benches.
yes,
Regular bench.
is having the roster.
The court which is having the provision.
Much obliged.
Item number 27, Sri K. Kalyani, Public Prosecutor, Sri P. Anand Lal.
But I beg to represent Mrs. K. Kalyani, the petitioner in the above revision.
Yes.
There is already a stay, my lord. The revision arises out of an order adding the petitioner's hearing as additional accused, an offence under 302 and 307.
Yes.
Now, earlier the matter was heard, my lord. I leave it to your lordship. Any convenient day, lordship may fix and we'll continue. It has to be finally argued, my lord. There is already an interim stay in our favor.
It's expiring today. It's
Expiring today, my lord. It may be extended and posted to any date subject to lordship's convenience. It's a matter of final hearing.
For unofficial respondent de facto complaint. It may be extended until further orders and its date may be fixed for final hearing.
He has no objection, he says it may be extended until further order and date may be.
Very well. I leave it to your lordship's convenience and my friend's convenience.
Until further order. And list for final hearing. And list it, shall I list it in January?
Very well. Lordship may formally admission may be required because.
Admit and list for final hearing, January, what is the date?
Obliged.
January 25th.
Much obliged. No, not 25th, but after 26th.
After 26th.
Any date after 26th.
29th?
Much obliged. I am deeply obliged. Obliged.
Item number 28, Sri Mohammad Nazir Pasha, Public Prosecutor, Sri Haridas Sharma.
May I please, my lord?
Yes.
Present revision is filed, my lord, challenging the MC order, my lord, passed by the ex parte, my lord. The page number 6, my lord.
The representing husband or wife? There is presenting whom, husband or wife?
Respond number 2, one my lord, 1, 2, 3 filed the MC, my lord. And they obtain the ex parte decree, my lord, maintenance.
I am returning on behalf of Haridas Sharma. His relative has expired. But request to grant 1 week's time, Your Honor.
My lord, one request, my lord.
Not request.
They are taking several adjournments, my lord. There is urgency, my lord.
What agency is there? What agency is there?
It is a ex parte decree obtained by the respond number 1, 2, 3, my lord. Thereafter, insisting for maintenance, my lord. He is unemployed, my lord. He is unable to maintain himself, my lord. Meantime, my lord, stay may be granted.
Have you filed set-aside petition then? If it's ex parte order?
Yes, my lord. Yes, my lord. That was returned, my lord. That was returned by the trial court, my lord. I filed the copy before your lordship, my lord.
Take up next week.
Much obliged.
Obliged.
Be ready with the matter, otherwise I can remand it back to the court below so that after hearing opportunity they can pass an order.
Very well, my lord.
We'll list it on 14th. Is it okay?
Obliged. 14, it's Monday, my lord. 13, my lord. 13 or 15? 14 is I'm not available.
13th is a holiday.
15, my lord. Kindly have it on 15.
Take up on 21st. Or
Obliged.
20th, take up 22nd. Just take up on 22nd.
Obliged, my lord.
22nd November.
Item number 29 CE Ramesh Chandra Gaur, Sri Kiran Kumar Puppala, Public Prosecutor.
Division is filed against the TSHC appeal below. The 36 days control delay. Now the counter has been filed. Now the delay is because the petitioner could not approach the council. That is the reason delay was occurred. 36 days.
Shall
The respondent to this case.
I allow the condemned delay? What do you say regarding the delay?
My submission was the case is starting to the individual council is the the reason to council could not.
We have the complete salary. Yes.
Now, I get two. That is seeking suspension of the from the order passed by the sessions court below. The auxiliary DVC below. The DVC was allowed by granting 10,000 rupees per month to the respondent number 1 and respondent number 2, who is the daughter. Total 20,000 and 10 lakhs as the compensation, awarded as the compensation. And that was being conferred by the sessions court by in the criminal appeal. Now the petitioner is regularly paying the maintenance for 10,000 each. Now what all I am seeking is there is stay may be granted in respect of the compensation is concerned. The appeal also 1/4 of the compensation amount was deposited.
Okay, compensation was deposited.
1/4 of the compensation.
Where is the order?
Order is in page number 6 is the criminal appeal order.
Page number?
6.
No, relevant paragraph regarding compensation.
The above discussion, right of page number 24.
Yes, para 27.
As confirmed by the trial court's order, it is not stated about the 1/4 of the deposit, but they can order part of the session court having order they have deposit.
Both things also considered you that the so and so is not entitled to set aside the order. Where is the lower court order?
Court order that I have not filed, but this is the copy.
And then how will I know where is how much compensation is ordered?
10 lakhs.
Where is that?
Is in appeal, your lordship may kindly see page number 6. Page number 6, last order passed by the trial court. The complaint is allowed restraining the respondent from causing any type of abuse against the petitioner or agreed person. This is the respondent is directed to pay an amount of 10,000 each per month. The petitioner and her daughter, total of 20,000 as monthly maintenance and residential accommodation. Next page. The above awarded maintenance residence charges shall be paid on before every calendar month from the date of travel in the He is also directed to pay compensation of rupees 10 lakhs. The petitioner get 2 equal discount from the date of the order. Therefore, against this order is appeal, we have filed an IM seeking stay. In that the sessions court has directed me to pay 1/4 of the amount. I have paid that amount. The order is
Where is that order? So you have paid 2 lakhs by 50,000. Where is that?
Order is here. Order is here.
Yes, what do you say?
Because my respondent unemployed to
So what do you say regarding the 1/4 of compensation? Did she receive? Huh? What is it?
We have information regarding the deposit of the amount.
Did she receive a master? No information. Okay, I'll list it on 14. Take instruction. 16. Shall I give 17? 16 I'm not, 17.
Item number 30, CKR KV Prasad, special PP for CBI.
You can place any material evidencing that you have paid.
I will file those out.
Check that we can.
Increments. Thirteen.
Some representing for the council for petitioners.
Yes.
If for CPS ready, I would like to conduct for passport. Actually, Lordship already in the 12th court also passed over the Lordship. I have to attend it.
Shall I extend the interim order?
Yes, your Lordship, but fix one day with the
Because
continuation.
the same submission was made last occasion. You are busy in other court. And same thing I will extend it. I'll extend what it is there. Whenever you want, you can come and argue. The interim order granted earlier, extend it. Or shall I say until further orders? Whenever you want, you can argue.
Fix the date, your Lordship, we will argue it.
Okay, December 28th. And the interim orders granted earlier, extended till then.
Item number 31, C MPK Aditya, public prosecutor.
Extension of interim orders take some time for final hearing. But it's an application because a petition is filed against the dismissal of discharge application. So.
Interim orders are there.
There is an interim orders not to frame any charges against.
What is the offense?
Its offense is under 406, 420, Money Circulation Act and Depositors Act. Petitioner before your lordships is A2. Even his brother used to do all the business, was none of the statements speaks against him. But there are 7 witnesses who are examined, and all those witnesses have specifically mentioned about his brother's role. Because at the time of the starting of the business,
Who is representing the?
Address the left.
Paper publication is ordered, none was appeared. But lordship posted for file hearing, I'll argue.
Is it admitted?
Yes.
Admitted. Okay.
Orders are extended till today.
Noted.
Interim orders granted earlier extended until further orders. Matter is admitted and listed for final hearing. Listed somewhere in January. January 28th.
Did you?
Oh, sorry. January 28th is Sunday.
Lordship's convenience.
It is 29th.
Publish.
Item number 32, CP Ramasharana Sharma, public prosecutor, CCH Venkataraman.
No representation. You are representing, sir? No, who is representing 32? Okay, no representation for it on either side. List on December 14th.
Page number 4, item number 33 and 34 are connected matters, my lord. Sri Pasha Mohit, public prosecutor, CP Giri Krishna. Who? 33 and 32. No represent.
32 just now. Whom you are representing? And what about the second respondent? There's no, I listed it to 14. See that he is present. Without his presence, I can't. Yes. No representation for respondent and witness. Yes. No representation with the petitioner. 14-12. Yes. 33.
We are sitting on the wrong side.
Yes.
We did because no. No. That's my last subject.
Yes.
Because there's 2 individuals connected to it. Arising out of SC 194 of 2014. Sorry. in first division 714 of 2021. 714 of 22.
Yes.
Has been filed by A4 and A5, who are made accused millets under section 319 CRPC. So far as other 715 is concerned, millets.
Yes.
A1 and A3 millet has filed 715 of 2022. Questioning millet altering the charge under section 6 from 306 to 304.
A1 and A3.
Yes, A1 is the son, A2 father, A3 mother. Yes, A2 is normal. The A1 and A3 is filed. Other revision is filed to A1 and A3. Son and mother. Father appears to be no more. A2. Yes, sir.
And who are A4 and A5?
A4 millet is the sister of millet, sir. A1.
Okay.
Millet A5 millet is the A4 is the sister of A1. A5 millet is the husband of A4.
Yes. Yes.
There is another case millet where wife died millet the suspicious circumstances. The marriage had taken place millet on 24/7/2013 minutes. Sorry, 19/3/2008 is the marriage. Had taken place on 19/3/2008. She committed suicide millet on 24/7/2013.
24/7/2000.
2013 minutes. Monthly minutes. It's 7 years millet.
Yes.
10 minutes. The statements were recorded, 161 statements were recorded on 31/7/2013. The trial has commenced. The trial has commenced and PW1 made the previous deposition on 9/7/2019. These are the 4 dates. 9/7/2019, that is the evidence of PW1. That is when he is coming and deposing the.
Who is PW1?
PW1 is
Father
the
or
father
the-
of the distributor.
Father of the-
13 is the 161 statement and 2019 is the evidence on record. Your father is
13 or 31?
2013 statements were recorded.
Yes, 2013, July date.
31/7/2013.
31/7. I was-
Lordship may also note another date. November 2013.
And 9/7/2019 is a deposition of PW1.
Then leaving this plan, 2 more dates. The initially in the FIR, I am arguing only first case 319. I will come to the third case later. In the FIR, the petitioners were shown as accused. The petitioners A4
and A5.
They were shown as accused. Then during the investigation, PWs 1 to 3, who are the material witnesses, categorically stated before the investigating agency that they falsely implicated these 2 persons. We were, due to the death of our daughter, we were in a sorrow condition. So we named them also. That's the statement of 161. Then the charge sheet was filed in November 2013. 29/11/2013 charge sheet was filed. Now, after the evidence was recorded in 2019, the learned judge by order date, the state filed application under 390
23/1/2020 years. That is criminal LP 102 of 2020.
23/1/2020. 2020.
Yes. 102 of 2020 criminal LP years. The learned judgment by order dated 20th September 2022, 29/2022 years. Allowed the application and directed to issue summons to both the petitions. Questioning the order passed by the learned judgment, the present revision was filed.
Yes.
And this one was the grant to the equal stage at the admission stage. The doctor was fast tracked as learned judge.
Yes. What are the grounds, sir? Solution.
Under section 319, there is a special provision of the CRPC, where after commencement of the trial, the court is vested with the power to add any person as an accused. The power has to be exercised cautiously, and there should be not only prima facie material, but also the material should be in such a manner that court should come to the conclusion that there is likelihood of conviction of this person basing upon this evidence. But evidence is in two parts. In Hardeep Singh Miller, the Honorable Supreme Court has taken the view. Even the statements recorded and the documents gathered by the investigating agency can be treated as evidence for a limited purpose. But the deposition before the Honorable Court or the evidence under the Evidence Act. Now, I bring to Lordship notice the FIR. The statements recorded by the investigating agency. Also, the statements recorded by the MRO during inquest. Because there is no need to produce the statement, my friend has filed it. I bring to Lordship notice. Lordship can take the FIR page. FIR is at page 19. Complaint is at page 23. There's some mistake. They have not added that next FIR. Lordship can take page 19 the FIR. Initially, the section was made under section 340. The crime was registered. Occurrence of offence on 24/7 at 2 p.m. Then mirrored information to the police on 25/7 at 3 a.m. it appears. Then minutes go to page 23 minutes. I read Telugu minute or 25 translation.
23.
23 is Telugu version.
It's better we read 25.
Yes. Business residing in China. I had one daughter who son on 19th 2000. My daughter also married to Masa Jagan A1. As per Hindu rights, during the marriage, they gifted her 10 lakhs silver, 50 crores of silk. In addition, they gifted her 6 acres of paddy land. After that, the time of East Pravina and Chandro, treasurer to change the gift and so on. I make the same gift with 3 acres to my daughter, 3 acres to my son-in-law. With my own registration in churches, provide duly vetted. As per the demand, I gave additional 1 lakh to 5 tulas of gold chain and 3 gold rings to his son-in-law and his sister Katya. Today, that is son-in-law and his sister Kalpana, her husband Satyanarayana. These are A4 and A5. My niece Purnachandra, his wife Pramila could not sleep without above additional payment. With that, my daughter and son-in-law put up their family at Moti Nagar, Hyderabad. But now and then, son-in-law's sister Kalpana A4 and her husband Satyanarayana A5 used to go to my daughter's house with the demands to bring additional ID, saying that we have much attached to your father. Why did you not? What did you do with the said assets? But I just read it Telugu, the exact portion was not translated properly. Only the last two last 6 lines. That means the demanded amount. Ma alludu, Ama Chelleru Kalpana, Ama Bharta Satyanarayana,
మా వేంకుడు పూర్ణచంద్రరావు, that is not A2, PM Pramila ఒప్పుకోలేదు. So this allegation is that these people did not agree. Well, till the amounts were paid. Only when disagreement, there is no demand. Allegation is disagreement. Then you rush me. ఆనాటి నుంచి ఈనాటి వరకు మా అల్లుడు కుమార్తెలు హైదరాబాద్ మోతీనగర్లో కాపురం మా అల్లుడు కుమార్తె హైదరాబాద్ మోతీనగర్లో కాపురం చేస్తున్నారు. కాగా హైదరాబాద్ లో మా అల్లుడి చెల్లెలు కల్పన, ఆమె భర్త సత్యనారాయణ పదే పదే మా అమ్మాయి ఇంటికి వెళ్ళి డబ్బులు తేరాదు, మీకు చాలా ఆస్తి ఉంది కదా, మూట కట్టుకుపోతారంటూ తిట్టి కొట్టి వేధించేవారు. ఇటు విషయం మా అమ్మాయి ద్వారా తెలుసుకున్న మేము నాగబండి శ్రీను మరియు శ్రీను తీసుకుని వచ్చి మీకు కావాల్సిన చట్టం ఇస్తున్నాం కదా, ఎందుకు మా అమ్మాయిని నిలిచిపెడుతున్నారని మందలించి వెళ్ళాం. కాగా కొంతకాలం బాగా నుండి మరలా యథాప్రకారం హింసపెడుతున్నారు. మా అమ్మాయి చెప్పినప్పటికీ మేము సర్దుకొని పోవచ్చు కదా అని గత వారం రోజుల క్రితం మా అమ్మాయి ఆడబిడ్డ కల్పన, ఆమె భర్త సత్యనారాయణ, మరిది ఉప్పల శ్రీనివాసరావు, గంగాధరరావు గత వారం క్రితం మా అమ్మాయి వాళ్ళ ఇంటికి వచ్చి మా అల్లుడు, ఆమె భర్త, మా విజయంకుడు గ్రూపులు కలిసి జంగారెడ్డి కూడా ఇంకో సంబంధం ఉన్నట్టు వారు ఇంకా కట్నం ఇస్తారని మాట్లాడుతూ నా అమ్మాయి తనగా మా ఫోన్ ద్వారా చెప్పగా, మా అమ్మాయి తనగా లక్ష్మి కైలిస్తుంది, మా అమ్మాయి తనగా మాకు ఫోన్ ద్వారా చెప్పగా మేము పట్టించుకోలేదు. మినిట్ ఫర్ మినిట్ ఇయర్స్ These people went there and harassed them. That is the statement given by the deceased to the parents. This is only but a hearsay. There is more than material. They say that this is only worships are level aware. Direct evidence is one aspect. Where there is a hearsay evidence, unless it is substantiated, that cannot be taken into consideration. Next sentence. Ante ka ma ammai chalipete, ఆమె పేరుతో ఆస్తు కూడా చర్చించుకున్నారట. కాగా పతనంపై పథకం కారణం అసలు వదిలించుకోవాలని మరొక ఆ పేరుతో స్థిరాస్తిని పొందవచ్చు, మరొక పేరుతో డబ్బు సంపాదించారు. ఈ రోజు అనగా 24 minutes, you lost the kindness period above. There is no date period for that. The entire transaction happened earlier, there is no date. కాగా ఈ రోజు అనగా 24/7 2 గంటల సమయం మా అమ్మాయికి ఎన్నిసార్లు కొట్టారు. Now, here FIR what I am submitting there, absolutely there is no material to show. Soon before that there was any harassment. There is no date, not time. 306 is already there. Abatement comes.
What is the date of that?
24/7. This is on next day. I think this is on 25. Yes, this is on 25/7. Next day morning he gave the report.
Now read the last paragraph on page 24.
కాగా ఈ రోజు 2 గంటల సమయంలో మా అమ్మాయికి ఎన్ని ఫోన్ చేసి ఎత్తకపోవడంతో మా అల్లుడికి ఫోన్ చేశాడుగా, మీ అమ్మాయి ఉరి వేసుకుని ఆత్మహత్య చేసుకుందని తెలిపినాడు. మేము అటు వార్త ద్వారా హైదరాబాద్కు వచ్చి గాంధీ హాస్పిటల్ నందు ఉన్న మా అమ్మాయిని చూసి వచ్చినాము. కావున తమ దయతో విచారించి మా అమ్మాయి మరణం కారణం అయినా మా అల్లుడు వాసా జగన్, అతని చెల్లెలు కల్పన, ఆమె భర్త సత్యనారాయణ, తమ్ముడు గంగాధరరావు, వియంకుడు పూర్ణచంద్రరావు, వియ్యప్రాల ప్రమీల, అమ్మాయి ఆడబిడ్డ మధ్య శ్రీనివాసరావు తీసుకుంది. This is the affair.
And what about the above paragraph? According to you, there is no date mentioned. When is that harassment?
They don't mention the date and minutes. This is only what the deceased stated. 32 minutes can be invoked only if the cause of death is informed to others. That's the oral right declaration. It is not the cause of death. She only informed that they are coming and demanding dowry. Then she committed suicide subsequently. If there is no proximity for making a demand dowry or soon before death under 304B, they can be charged under 306. Either 302, 306, 304B, 3 offences are available. Murder is not there. Abatement to commit suicide because she committed suicide. So in this situation, what happened? You lost me kindly take only one statement and treatments because this is not necessary during the course of the inquest. 22 one statement you lost my kindly take. That is part of the record. I should give you lost it notice. Where 22A minutes. This is the statement of the father given on 25/7 before the government. Because your lordship there is suspicious death. Inquest will be conducted, statutory inquest will be conducted. They examine the eyewitnesses. Whatever they have stated in the FIR, same is stated before the government. Just my last 5 lines of lordship minutes. I have registered 3 acres of land in the name of my daughter and another 3 acres land in the name of her son-in-law, Jagan. After marriage, her in-laws, as is detailed below, started demanding additional dowry and harassed her. This is Lakshmi similar. After marriage, her in-laws, as detailed below, started demanding additional dowry. Then Vasa Purnachandra, father, Vasa, Amira, mother-in-law, Kalpana, the first petitioner, second petitioner, Satyanarayana, first petitioner, Upal Srinivasa is an accused. I met their demands with the raised and paid to the tune of 4 lakhs in the span of 5 years on marriage. On 24/7, around 2 hours, my wife called Jagan. Jagan informed that she Prasanna Lakshmi from suicide. Now, this is the statement made before the MRO. This statement was on the same limits. Kindly note, but you would get a 22A. Statement is on 25/7. On the date of FIR, inquest was conducted.
Where is the date? 25.
In the top list, affirmed and state on oath as follows: 25/7/2023. Third line from the top.
This is 25/7.
Yes. So the FIR is on 25/7. The statements were also recorded 25/7. Then the after investigation was commenced. Then he started recording the statements of all the witnesses. 44 minutes.
Right. 44.
One submission. So far as the inquest is concerned, there is no evidentiary value except the cause of death. So the statements cannot be relied upon for any purpose in the trial. The inquest statements, they are only the statements that were recorded only with regard to the presence of the eyewitnesses and then the cause of death. So these statements are irrelevant so far as the present list is concerned. Now 44A is Rashmi Country. These are the statements recorded by the eyewitness. Last paragraph. 44A minutes. Last paragraph. I falsely stated to the inquest officer that the son-in-law's sister Srimati Uppal Kalpana and her husband Satyanarayana, who are also residing at Hyderabad, are frequently come to my daughter's residence and harass her and abuse her and used to beat her to bring additional dowry from her parents. My daughter informed the same to me, but I falsely said all this out of anger in the wake of my daughter's death and gave a lot of cash in silver and gold and gave land of 6 acres. And I thought that by implicating the petitioner, husband Satyanarayana and his 2 brothers, we could better leverage to get back the valuables from them back. Similarly, I wrote falsely in the petition for the FIR that in order to set my daughters from the right, I along with N. Srinu and C. Srinu went to my daughter's residence and admonished my son-in-law and his family members. And I wrote falsely that 1 week before the death, my daughter had informed over phone to me that her husband Jagan's sister Kalpana and her husband Satyanarayana, brother-in-law Uppala Srinivasa Rao and Gangadhar Rao discussed to perform second marriage to her husband to get more dowry, and also were discussing that as she died, the whole property of my daughter will go to the husband. This kind of statement on them I made falsely in order to get an advantage in getting back all the valuables we gave in marriage and also out of shock on my daughter's return. To speak truth, I did not take N. Srinu, C. Srinu, who are my relatives, even to the house of my son-in-law, and my granddaughter and my daughter's marital affair. Further, my daughter never had told that Kalpana and her husband and her brother-in-law had gone to my son-in-law's house in order to discuss anything related to second marriage of his bride in Jangareddy. But for my daughter's death, my son-in-law and his father and his mother are responsible for none other than responsible. Further, now we have shown a notebook which contains certain writings on 1 page and 6 pages of writing by the police, and we were told by the police that these 2 documents have been seized from the house of my daughter. On observing them, it is apparent that those writings and all the 2 documents are that of my daughter. And in all the pages of 2 documents, she wrote all that she had been told to us regarding the treatment to her during the marital life in her home in Rampalakotam by Jagan and his parents respectively. I make it clear that only Jagan, Purnachandra Rao, Pramila A1 to A3 harassed my daughter on her not having children, not for any additional reason. But Kalpana, Satyanarayana and his brothers have no role in the death of my daughter. Therefore, we do not like to implicate these 4 persons in this case, but that they promised to give back the entire property that had been given to Vasaji. This is the statement of Father Miller. Father Miller categorically stated before the investigating agency that these 2 persons were not responsible for any of the transactions that transpired prior to her death, and they were falsely implicated, and these people never visited the house also. Then Miller pleaded to Mother Miller, PWD mother, I will not take much of the 44 B.
Now, is the complainant this statement on 22A and 44A?
The father is the complaint.
This is PW1. This
PW1. LW1.
LW1 is PW1.
Yes, now it's PW. Only one paragraph from mother. 44C or 44B minutes. Second paragraph.
44B.
T minutes.
T.
Or D minutes. Second paragraph. Mother's statement. It is also false that there was a proposal of getting my son-in-law married for the second time by his sister, her husband, and his 2 brothers. This kind of a statement on them being made falsely in order to get an advantage in getting back all the valuables we gave in marriage, and also out of the shock of it. Further, I stated falsely to the deputy Tahsildar that we had given 4 lakhs to Vasa Jagan and her parents during the 5 years of marriage, but this was the rent on the 6 acres of agriculture land which she had given away to her daughter and to her son-in-law. Now Jagan and her parents agreed to return said land. Then last penultimate para, I make it clear that
we have clear copy of this 44D. It's not legible here. Approximately, I could understand because we are reading. Just see this. Like if I have to record anything about the deposition for future, I may have problem. Not at all
no,
clear.
my copy is very clear. How this is happening. It's only this copy, photocopy.
You can give it later so that if I have to record any statement.
I'm giving.
It is not filed lordship 714 of 2022. My case date not filed lordship.
Then what they change it. So what is that you wanted to rely on from that?
Same way, mother also states that the copy, just admit the copy. Only she also states that only 3 persons are responsible.
Okay, same statement.
Same
as her husband.
As husband, she also stated. Similarly, minutes. Then ultimate only 2 sentences. I make it clear that only Jagan, Purnachandra, and Pramila harassed my daughter, and that not having children and not for action dowry. But Kalpana, Satyan, and 2 brothers have no role in the death. Then last paragraphs. They took the dowry at the time of marriage and they did not ask for any action dowry. This is mother's statement. Then next is brother minutes. 44C. Rashmi kindly go to 44 E minute, 44 F. It is also false that there was a proposal of getting an.
Who is he? LW3?
He is brother.
Brother of A1.
Brother of brother.
No, sorry, brother of the deceased.
She is also PW3 minutes. Only 1 paragraph, so 44 F. It is also false that there is a proposal of getting my brother-in-law married for the second time by sister and his 2 brothers. This kind of statement on them we made falsely meant to get advantage in getting back on the value. But this is the minute.
Lastly, they say falsely stated to the inquest Tahsildar.
According to these 3 witnesses, there was no demand for dowry, and these 2 persons are no way connected with the entire transactions. Only parents were harassing for not begetting children. Then charge sheet you Rashmi kindly take for me. Page 27 is the charge sheet.
28.
27 is the charge sheet. Let's start at 27.
Yes.
Case 38 minutes, your Lordship can go ahead. 38 last paragraphs. Whatever minute is the statement recorded, he mentions here. But on being examined by me, the petitioner stated that he had implicated A4 to S1 because they were shocked by the death of Prasanna Lakshmi and they had given large amounts of money. You must be leave it there. Go to next page minutes. Whatever the entire statements are extracted, then second paragraph. On comparing the facts revealed by the writing of the victim in two written sources with the current statements of witnesses to me, it discloses that only A1, A2, and A3 committed the offence and none other than these three. In all the statements, the witnesses stated blaming all the accused on the similar thing, but when going through the agony writings of the victim, she did this. You lost me. This may be minute or 32 admissible. She did not name A4 to A7. The victim's sister-in-law, sister-in-law's husband, and two brothers. Further, the victim did not write anything directly attributing to A4 the sister-in-law as having did or said by her, whereby victim could have hurt physically or mentally. And there is no mention of A4, A5, A6, A7 in writings of victim. The victim made accusation in writing mainly on the husband, the next mother-in-law, and the father-in-law. Then minutes, next page 40. 3 minutes, there minute he has taken advice of the land public prosecutor and then minute from the DCP. So far, these four persons are concerned, their names are deleted in the charge sheet. Then, interestingly, what they have done is
these are A4 to A7.
A4 to A7, but now only A4 and A5 minute 390. A6, A7, nothing has changed. You rush me take 5 minutes. 45 minutes is the repetition order passed by the Honorable Court. Where the defendant complainant approached the Honorable Court seeking a direction that meant that because charge one fact, the charge sheet was filed under 306. 304B was deleted. So the defendant complainant filed by father filed a petition seeking a direction to add 304B. Also would get in the first parameters. The present petition came to mind Vishweshwara, PW1, who was informant so. The said case was investigated, charge sheet was filed for the offences under 498, 306, 34, 3 other W provision. On committal, they was membered as SC number so Hyderabad, challenging the order taking cognizance for the offences punishable under 498A and 306, 34. Though the first investigation report discloses commission of offence punishable under section 304 BIPC, the present petition came to be filed to treat the investigation done as stated one and consequently to reinvestigate, the new investigation, fresh investigation. But this was the prior in the petition. Minutes may kindly take page 51 minutes. Sorry, 57 minutes.
57.
Yes, 57. Last pyramid, there are 22.
Yes,
The 161 statements of witnesses which are placed on record by the petitioner himself do not anywhere clearly go to show that there was harassment of very soon before. Though I am arguing with 319, somewhere it may be overlapping the 216 also. Because now there is an order whereby learned judge converted 306 to 304B. You will also see the order passed by this honorable court. Petitioner himself do not anywhere clearly go to show that there was harassment of dowry soon before death, warranting filing of charge sheet under 304B. It is true 161 statements of the petitioner show that dowry was paid at the time of marriage, for which the accused of charge for the offence of section 3 of the Dowry Prohibition Act. Then the learned judge has extracted LW1, para 23 minutes. Though the last pair referred to show there was harassment to bring additional dowry, which was informed to the petitioner, but the same is silent as to when such demand was made, as the marriage of upon in the year 2008 and the death occurred in 2013. Similar is the statement of LW2, wife of LW1. Then let's, apart from that, the governments in the counter of the inspector clearly show that the entries made by the deceased in the daily relates to the harassment which hands of accused 1 to 3 only. No doubt the contents of dairy are subject to the abuse percent, but primarily the material before the agency was mainly against A1 to A3. Therefore, this court of the view that's not a case where warrants fresh investigation. Learned judge while dismissing minutes, when I lost the kindly 26 minutes. having regard to the material available on record, this court is of opinion it's not a pit case where fresh or de novo investigation can be ordered, but since the petitioner is aggrieved by the investigation done, he is always at liberty to provide the remedies available under CRPC. So, madam, what I am told, madam, that the defect complaint filed a protest petition, subject what my friend says there, and protest petition was dismissed for non-prosecution. But this I am stating without the document on in paper in hand. My friend has instructed me that it was dismissed for non-prosecution. Once your lordships are available, you are aggrieved with the charge sheet. You have the only remedies available to CRPC. So
against this A4 to A7.
You cannot say that. My friend may have to say whether it is against A4 or whether against only 304B. Suppose the protest petition is only for 304B, then they can subsequently make an allegation that can be included under 319. Suppose otherwise, they have filed protest petition against A4 and A5 also, and the same was dismissed for non-prosecution. Again, can 390P.
Then I'll ask the public prosecutor to place.
Record is there.
According to them, protest petition has been filed, but whether it is regarding the offense itself or the adding of those,
399 of
whether deletion of those A4 and A5, you have to specify. Then we can. This is what is.
Then 390 petition for ability to lodge case 61. Then I'll come to the evidence. Case 61 is the state filed this petition. Second paragraph. It is submitted that during trial, PW1, the father of the deceased was examined as PW. LW1 was examined as PW1. As per the evidence of PW1, it is revealed that his daughter used to inform him that Kalpana, who is sister of A1, and her husband Satyanarayana came to the house of A1 and harassed her daughter by saying that she brought less dowry and demanded for additional dowry, and further deposed that 1 week prior to the death of his daughter, A2, A3 came to the house of A1. Thereafter, they called their husband Kalpana Satyanarayana, who resided at Secunderabad in the house of A1. At that time, brother-in-law of Kalpana also came to the house of A1, and thereafter all of them discussed to perform the second marriage of Kalpana. There is one good marriage against the Jangareddy, and they would get more dowry and property. But this is the petition basing upon the evidence of PW1. Now, my lords may kindly take the PW1 evidence.
And the petition itself, they are saying 1 week prior to the death of his daughter.
Is that now evidence they can improve, but I'll also give you lots of the judgment.
No, which is advantage to.
Yes.
Because 304 is 304B is soon before the death.
And that is the trial minutes, your lordship's vast experience. That these are the contradictions, omissions basing upon which we seek for acquittal. 161 statement.
Basing on the statements and even.
Now, sometimes 161 statement, FIR name is there. 161 it is silent. Evidence they speak about, still courts will say there is a omission which are
based on the evidence of the witnesses, they will be arrayed as accused.
Now, LW is categorical statement that we need a false statement against them.
Yes.
Can they come again and depose against these persons? LW1 minute for a minute, 44A. Sorry, 77 minutes. 77. Minute 77 is the minute evidence recorded 9/7/2019. My last book I did after nearly 7 years. That's 78. Fourth paragraph. Thereafter, my daughter used to inform me that one Kalpana, who is sister of A1 and her husband Satyanarayana, came to the house of A1 and harassed her that my daughter brought less dowry and demanded for additional dowry. 1.5 or 2 months prior to the death of my daughter, I came along with C.S. Srinivas, Nagabad Srinivas, so on. So this is minute 1.5. He goes to minute 1.5 or 2 months prior to the death. Then minute 79. 1 week prior to the death of my daughter, A2, A3 came to the house of A1. Thereby they called their daughter and son-in-law by name Kalpana and Satyanarayana, who reside in Secunderabad in the house of A1. At that time, brother-in-law of Kalpana also came to the house of A1 and thereafter all of them discussed to perform the second marriage agreement as one good marriage arranged at Jangareddy and would get more dowry and property. I came to know about the said fact from my daughter through phone. Then I informed my daughter not things were happened and not to give much importance to that. But this is the evidence not basing upon.
No, but what about the cross-examination?
The cross-examination will definitely. But two proposals I think you also notice. One is.
So just now you have shown me 22A, I mean 44A and 44B are held. Those are 161 statements.
161 minute, we can put it only.
I hope.
But here you also see 86 minute the.
That's what, whether the omissions or contradictions were marked.
85 you lost me candidate minutes. PW and present and sworn in for continuation of cross examination. This is 25/7/2019. Page 86 minutes. It is true. It is true. I have not stated in Exhibit P1 in my 161 statement and also before MRO that A1 used to harass my daughter by saying that she got very less and demanded pay further action on me. In spite of harassment of A1, my daughter led the conjugal life with A1. Then it is true I have not stated in Exhibit P1 in 161 statement. My daughter requested A1 to approach the doctor, but it did not show any interest. Then it is true I have not stated in the 161 statement and also before MRO. My daughter used to inform me that this is Lakshmi. My daughter used to inform me that one Kalpana, who is sister of A1 and her husband Satyanarayana came to the house of A1 and harassed that my daughter got less dowry and demanded for additional dowry. It is not true to say that I have not mentioned in P1 that my daughter used to inform me that from Kalpana, who is sister of A1, her husband came to the house of A1 and harassed her. So the suggestion he has admitted, 161 he has not stated with regard to the coming minutes. Then 87 minutes.
I was evidence. 87.
87, next page minutes. It is true I have not stated in P1 that by 161 statement before the MRO, my daughter informed that A1 is to tell her that as per the horoscope he is having second marriage. Then the next paragraph. It is true I have not stated in 161 statement and before MRO that 1 week prior to the death of my daughter, A2 and A3 came to the house of A1. Thereafter they called their daughter and son-in-law by name Kalpana Satyanarayana, who resided at Secunderabad to the house of A1. At that time, brother-in-law of Kalpana also came to the house of A1. Thereafter, all of them discussed to perform the second marriage of A1 as one good marriage alliance of so and get more dowry. Then it is true I have not stated in P1 in my 161 statement and before MRO. We are strongly suspected that the daughter not committed suicide, but she was killed by A1, A2, A3 and sister brother-in-law of A1. This is the cross-examination done by A1 to A3. Well, I may bring to lordship notice two proportions. Accused is not entitled for notice before 390. That your lordship are aware. No notice to be given to the accused. If not somebody is made an accused, then de novo trial has to be conducted. Because PW1 is the person who stated against the petition. For all they continue to be accused, de novo trial has to be conducted. Then with regard to 390, recently 5 judges the matter was referred to 5 judges. What stage 319 can be moved? The constitutional bench has held at any stage before pronouncing the judgment. Even after reserving the judgment, 319 can be moved. That's the military. I pass on those judgments. So, in view of this, the order has been to lordship notice. And it's squarely covered by Hardeep Singh 5 judges judgment and subsequent several judgment. The material should be in such a way that it should be clinchingly established that there is a likelihood of conviction. I'll ask the kindly similar, they are not disputing 161 statement. Let's suppose there may be a case. They will say my statements are 161 recorded without or we have not stated like that.
Now, what about IO's evidence?
Not yet. Before that,
now, what is the stage now? Which evidence is going on?
PW3 at the stage we got stage. After PW3 petition was filed, petition was allowed on what date?
No, but as of now, however, it shows you have made that contradiction.
Yes. Isla is blood, the 319 cannot be invoked casualty. There should be potent material. Inspiring evidence should be there on record to show that court should give a finding. This material is sufficient to record conviction. The court will not record, they are likely to be convicted. But the evidence on record is sufficient to convict. Only I am left with the order copy, the order passed with the learned and 3-4 judgments. We get your lordship after.
Yes, sir. We'll continue after lunch. In both the matters, we are going to argue today.
See, other matter, nothing is, but the 3 already the lordships are seen.
Yes,
The 304
only regarding them.
Yes, 306 illegal, they are being prosecuted. Soon before death is not their merit that your lordship will not permit them to claim a charge under 304.
They themselves are saying 1 week back.
Yes.
Harassment has been. Here after lunch. What is?
Item 43, senior counsel is hearing next Tuesday.
Okay. Inform the respondent.
Already informed.
Item 42, at request of counsel for petitioner, list on
Senior counsel name needs to be printed. S. Anand.
S. Anand.
Anandi.
Anandi.
Yes.
Yes, yes. Counsel for the CBA name may be printed as Anandi, and at request of counsel for petitioner, list on 14/11.
That's all.
Continuation of matter, item numbers 33 and 34, Sri Pasha Mohit, Public Prosecutor, P.P. Hirikrishnan.
So far as the equivalent order is concerned, yes. Page 12 mentions the equivalent order.
Yes.
First, re-government of the SC number of 23/2020 for further evidence. During trial, elder P1 father of deceased examined as PW1, mother examined as PW2, brother examined as PW3. You lost me, can you go to page 14 minutes, 14B. The respondent further submitted, this court has fixed trial on so and so. After receiving summons, deferred complaint approached by court by way of filing WP, the obtained interim stay assets. Subsequently, the Honorable High Court disposed of the petition with direction deferred complaint approached by way of filing total petition. Accordingly, the deferred complainant filed criminal MP 256 of 2018 in crime number 583 of 2013 before second edition Chief Metropolitan Magistrate Nagpal to do cognizance against Kalpana and Satyanarayana. Same is pending. My instructions are not, that's what you will directly run by the prosecutor. This was mere dismissed for non-prosecution. Then you will go to page 50.
So according to this is regarding the same petitioners.
Same thing. Against these two petitioners, they filed a protest. First petition was filed, that was dismissed. Protest petition was filed. My instructions are that it was not pending, it was not prosecuted. It was disposed of on 2/9/2022 case next. Criminal MP 256 was disposed of on 2/9/2022. Then let's go to page 15, the discussion of the learned judge. The learned judge accepted every proposition laid down by the expert to Rashmi Sriva. The counsel for the accused submitted a report, the patient report in the year 2019 of versus State of Gujarat. Where the Honorable Apex Court held that the constitutional bench has given a caution that power under 2019 is a discretionary and extraordinary power. It should be exercised sparingly in many of the cases where the circumstances of the case were wide. The crucial step which has been laid down as noted above is the test that has to be applied is one which is more than prima facie case as exercised at the time of taking charge, but short of satisfactory evidence that the evidence it goes unrebutted would lead to conviction. This will rush back. When the learned judge will refer to the judgment, then the counsel also placed on that is Hardeep Singh. I'll read Hardeep Singh separate units. But page 16 you rush back here. In section 390, the purpose of providing it appears from the evidence of any person not being accused as committed in offence is clear from the words of such person could be tried together with the accused. The offence is clear from the words for which such person could be tried together with the accused. The words used are not for which such person could be convicted. There is therefore no scope for the court acting under 319 to form any opinion as to the guilt of the accused. This is the finding of the learned judgment. Then minutes. Let's go to para 7. They used the entire material on record. The very basis of the case is the complainant was marked as P1. The complaint stated that his deceased daughter, son-in-law were put of family at so and so. And the sister of E1 by name Kalpana Satyanarayana frequently appears and harassed the deceased, stating that he could bring amount from her parents. Further, Kalpana and her husband, brother-in-law Kalpana by name Srinivas Rao and Giridhara visited the house of the deceased one day prior to the death of the deceased about the arrears to E1 at Jangareddy, and they discovered that the deceased death the property in both things. Deceased informed the same to the complainant. Further, the complaint referred the names of Kalpana and Kalpana as accused. On perusal of 161 statements, it was recorded by the police that PW 123 falsely stated before inquest that Kalpana and Satyanarayana harassed the deceased and wrote falsely in the petition that 1 week before the death, deceased informed over phone that her husband Jagan's sister Kalpana and her husband and the brother discussed to perform second marriage to her husband. When we looked into the evidence of PW 1 and 3, PW1 in the chief examination deposed that his daughter used to inform that one Kalpana, who is sister of A1 and her husband Satyanarayana, came to the house of A1 and harassed his daughter that she brought as dowry demanded for additional dowry Further stated that 1 week prior to the death of the daughters of A2 and A3 came to the house of A1. They called their daughter and son-in-law by name Kalpana Satyanarayana, who were residing at Secunderabad to the house of A1, and all of them discussed about the second marriage of A1. PW2 or 3 also stated before the court the same and the answer PW1. Then the finding is from the above document, it appears that while lodging complaint, the complaint raised an accusation against Kalpana and Satyanarayana. But while giving statements before the police, the complaint deviated the stand taken in the complaint. Whereas the complainant, PW2 mother, deceased with the brother of the deceased were giving evidence, categorically stated Kalpana and Satyanarayana also harassed the deceased. The counsel for the respondent argued in written arguments that the statements of PW1 to 3 are disproved in the cross-examination. No doubt these 3 witnesses, no doubt these 3 witnesses admitted in the cross-examination that they did not depose the same at the time of recording the statement by the police and MRO inquest. When the complaint evidence given before the court revealing specific voters against Kalpana and Satyanarayana, basing upon the statement recorded by the police in 1961 and before MRO cannot conclude that the persons proposed accused are not guilty. The counsel for the proposed accused argued that PW1 to 3 in the cross-examination stated that this is very frequently considered appearing but never expressed alleged difficulties and also admitted several material important evidence to is hearsay in nature. It is true in the cross-examination witness admitted the miscarriage and also the treatment of the deceased with regard to registration of land, Pasupu Kunkuma, subsequent I think that when it just come down, she came down here. Subsequent sale transactions, last minute, 3 lines, handwritten notes. Transactions and contradictions were also marked. Since the case is at trial stage, it is not fit and proper to evaluate the evidence for prosecution witnesses. But all the 3 witnesses denied the suggestion that the proposed accused are innocent. PW1 to 3 categorically stated the role played by the proposed accused. This court felt that there is more than prima facie case and sufficient material to proceed against Kalpana and Satyanarayana. Hence, it is a fit and proper case to summon Kalpana and Satyanarayana as accused to face trial together with A1 to A3. Accordingly, the point is answered the petition. Having referred to the ratio laid down by the apex court, the learned judge having noted down that these are the developments, all the omissions which amount to contradiction, again allowed the petition. But this is the entire material. So far as the power is concerned, 319 permits erosion. For 319, where in the course of any inquiry into or trial of contents, it appears from the evidence that any person not being an accused has committed any offence for which such person could be tried together with the accused, the court may proceed against such person for the offence which he appears to have been committed. Can you see the wording? The wording is very important.
So whether these petitioners were arraigned in the FIR?
FIR, they are there. They are there. 161 statement, they have given the explanation why these people were implicated as accused. The wording, the accused has committed an offence. So the court's conclusion should be the evidence on record would categorically prima facie indicate that these persons have committed the offence. Generally, all the provisions he is accused of an offence. The lordship will not get this committed offence. 319 million is a special provision, extraordinary power, where the court's conclusion should be that he has committed the offence. When he has committed the offence means there should be consistency from FIR, 161 statement and the evidence. We can test blood under 142 Evidence Act, the veracity of the witness blood with reference to 161.
The person, that any person not being the accused
has committed any offence, Now,
But in your case, they were made accused and police has come to a conclusion that there is no material place and against that final order, I think the protest petition also has been filed.
Protest petition was filed. All the remedies they have filed. Then the learned judge very carelessly has allowed the petition without reference to all those.
I think, I don't know, I am only coming to a conclusion with the terminology. I think this is what I feel from the provision of law. So we are not pointing out on that. Language shows who's not made an accused. But this is a case where protest petition also has been filed. Where's the evidence? Okay, what else?
I'll come to that. When such person is not attending the court, he may be arrested, summoned, circumcised the case maker for purpose of suppression. Any person attending the court, though not under arrest or upon summons, may be detained by such court for the purpose of inquiring into or trial of offence which he appears to have committed. Where the court proceeds against any person under subsection 1, then the proceedings in respect of such person shall be commenced afresh and the witnesses reheard, subject to the provisions of clause A. The case may be proceeded as if such person had been accused person, then the court took cognizance of offence upon which the inquiry or failure commenced. This is the power of 390. I just complete that also and give the precedents.
Okay, it shows the one Rajesh versus State of Haryana, where they were made as accused in the FIR. Later they were not summoned, not implicated in charge sheet, were also summoned by the court at 390.
I'm not.
But where there is a material is there.
The power is discretionary. Washington kindly consider this power is discretionary power. There is no set of ratios laid down in what circumstances it can be. But only question is that there should be the court's application of point is to the extent that he is likely to be convicted. But if you lordship take this penalty, when there is a omission which was not stated in 160, that is the ground for acquittal. The worships are referring to the case where what happens pretty FIR sometimes may be there. 161 they might have forgotten to tell them. In evidence they mistake. Or mirror, the statements were not recorded properly. But this is a case where there has been explanation why they were implicated also.
No, we were on the point where they are not arrayed as accused. Language shows.
Right.
But there is a judgment showing even though they were accused, they were. But there should be a material.
Yes, second case, I just read the story. And I give the precedents in both the cases. I give only number 390, 304B, and 216 here. Training lecture.
Second.
That's all. If they are 715, the impugned or submitted is that is 15 minutes. But this is an application was filed. So, frame a charge and the P0 for 3 minutes. instead of 306. Right, first we see the prayer. Before averment of the petition will take 15 minutes.
Yes.
The accused have been facing charges 306, 498, 34. PW 153 categorically stated the accused have proposed the accused in criminal MP number 102 have harassed the deceased with a demand for additional dowry. The deceased died within 7 years of marriage. In such circumstances, for adjudication of the case, it is just and necessary to alter the charge from 306 to 304B. That is the prior minutes. For learned judge minutes. Page 17 minutes, last therefore. Now the point for determination is that there are grounds to alter the charge. Review the entire material on the card. As per record of examination of PW 1 to 3, the prosecution has made criminal investigation. The summons remove the proof and the given petition is right. To alter section of law for criminal substitution of copy. As per our friends in complaint team, after knowing the fact of death of the daughter, the complainant and his family members went to their daughter and they were informed that their daughter committed suicide. Basing upon information, they asked complaint for the police to try for registered initially. The section 304B. While filing charges, the investigating officer got sanctioned the section of law 498, 306. The counsel for the accused internal arguments admitted that as an afterthought, the present petition is filed and deferred complaint admitted several facts in the cross examination. Further argued that the postmortem examination concluded the truth and clearly showed that the deceased died due to hanging and no abnormal circumstances performed. But it is the fact that the deceased is therefore enacted. Then T04B applies to the cases where the death of a married woman occurs between 7 years of age and the said death is unnatural and soon before her death she was subjected to cruelty or harassment by her husband or relatives or husband in connection with any demand for judgment. PW 1 to 3 in their evidence categorically stated that all the accused, including the proposed accused, harassed the deceased with the demand of a man and the daughter died due to the unbearable harassment. In the complaint also, the complainant not mentioned the same and due to harassment, the accused, his daughter died. On considering the exhibit P in complaints, the evidence of PW 1 to 3, this court felt that the ingredients of section 304B applies to the facts of case in hand, then you lost missing. Hence, the petition is devoid of any merit. That's what I see. Since the petition is devoid of any merits, petition is out. Let session judge dealing with the lives of the people. She can't pass as such an argument. She doesn't know whether the petition is devoid of any merit. Petition is in accordance with the law. These are all having a serious implication on the liberty of a person. Russian kindly say 306 minutes abatement to commit suicide. If there is no instigation merit, they can come out. 304B minutes, there is a statutory presumption. The consequences are very serious. When the consequences are serious, soon before death merit, she must record a finding where there is allegation of soon before death. According to the merit, they came after 1 week, before 1 week of the death, and that 2 minutes improvement. They themselves were stated in the 161 statement, they never came to their house before 1 week.
And one more aspect which is in your favor, they were reportedly calling her on phone, but she was not answering.
Immediately, the learned judge, when she wants to move 304B, the punishment is more.
I think when you were reading the complaint, I heard about that. So it shows there was soon before death, there is no communication between the deceased and the family.
Happens, but now there is some writings of the deceased. At least the writing should show that she was subjected to cruelty just before death. It is not the case of the prosecution. Nor Miller, it is the case of.
What is the date on the writing?
Letter minutes.
Any date?
The entries appears to be mirrored. My friend is stating 32 minutes days.
28 is the charge.
Here, you would find page 32, daily minutes. Page 1, 28/7/2010.
Okay.
10 minutes, next. 29/7/2010.
Date of incident is 13, I think. 2013.
Yes. 2008 marriage. These letters pertain to 2010. Page 45A minutes, PW1 statement before the police. Ask
45.
A minutes, 45A. Last pyramid. I falsely stated to the inquest officer that the son-in-law sisters Kalpana and her husband Satyanarayana, who are also residing in Hyderabad, are frequently came to my daughter's residence and harassed her, abused her, and used to bet her and bring additional dowry from her parents. My daughter informed the same. But I falsely said all this out of anger in the wake of my daughter's death and gave a lot of cash and silver and gold and gave land of 6 acres. And I thought that by implicating the sister-in-law and husband, which are two brothers, we could get a leverage to get back the valuables. And last but one. They took the dowry at the time of marriage and they did not ask for any additional dowry after. They received other articles soon after the marriage. This is the statement of the father. Other same repeated. LWS 1 to 3 same the state the same thing. There is not. 77 minutes per minute to rush for 2 minutes.
77.
The evidence of PW1 after 5 lines. The time of marriage.
Yes.
At the time after 5 lines, at the time of marriage, my daughter was given 10 lakhs cash, 15 cost of gold, 3K silver, and 6 acres of agricultural land, and so on. The Pudimanda West Godavari towards dowry to A1. We performed the marriage of daughter with A1 by spending expenditure of 5 lakhs at the Portugal City. At the time, A1 working as software engineer. 10 minutes. After the marriage, my daughter went to the in-laws house of stayed for 6 days. Thereafter, my daughter and A1 returned back to America and stayed for 2 days. Then we went to perform the marriage of my daughter with A1. At the time, A2 called me through phone and asked me to register 3 acres of land in the name of A1 and 3 acres of land in the name of my daughter. Otherwise, the bed marriage of my daughter with A1 would be postponed. Accordingly, I registered 3 acres of land in the name of A1 and my daughter each and performed the bed marriage of my daughter. A1 stayed in my house for 2 days. Thereafter, he went to his bed. Then we 78 seconds are on. Thereafter, my daughter and A1 started conjugal life by staying at Hyderabad. Thereafter, A1 used to harass my daughter by saying that she brought very less dowry and demanded to pay further additional dowry. In spite of harassment ever, my daughter led the conjugal life with A1. These are all not, they may come under 498 or beyond 498. For death merit, 306 charge is there. For all these harassments, alleged harassment merit, which led to the death of the person, 498 is applicable. 304 people. Unless they show minute that just before the death, lordship minute, seen minute, what is doing before death? Just before the death minute, there should be some instigation, some material to show minute that influence her mind to commit suicide. That is minute soon before death. 79 minutes, last one sentence. 1 week later the death of my daughter, A2 and A3 came to the house of A1. Thereafter, they called their daughter and son-in-law by name Kalpana and Satyanarayana, who reside in Secunderabad.
Are you admitting 498 is applicable to that?
That is the charge rates. On A1 A3, they are now charged 498A, 306, that is 34. They are facing the trial. For
This application is for only
A1 and A3, not the
A1 and A3.
A4, A5, there is no material. A1 and A3 are concerned.
So only for this application.
Yes.
Because A1, A4 again 498.
Everything is over minute, evidence has come on the card. If at all minute, the evidence is inspiring, the judge can convict them to 306, that is and 498. They cannot now dispute at this stage of the trial.
Only simple submission is soon before that there is no communication and no evidence.
No evidence on that. Hence, 304 minutes cannot be charged.
Anything else?
President split the completely elements.
I think it's a simple issue, don't need to go elaborate. The only ingredients of the offense, if they are not meeting out, it is sufficient. We can see the principle.
Just assemble this paragraph so that you know. Seven judgments totally.
Is there any doctor evidence placed in this case so far, or postmortem
It
report?
is a case of suicide. Nobody, there is no dispute with regard to suicide. Whether Mirror not for any unnatural death is there soon before that she was subjected to.
No, but I think it shows in the order also, no abnormal circumstances were found out. Order on page 18. It clearly shows the deceased was died due to hanging and no abnormal circumstances.
Yes. But even she dies by hanging, evidence is there that soon before that she was subjected to cruelty. For the conveyance book. But this is the leading judgment so far. 2014 3 SCC 92 Hardeep Singh's case. Not probably about but this case where their lordship saying that evidence means even the material collected by the investigating agency.
Which paragraph?
84. The conclusive portion with regard to the evidence. 84, page 132. The vote. Sorry.
Yes. One
84 minutes. The word evidence therefore has to be understood in its wider sense, both at the stage of trial, as discussed earlier, even at the stage of inquiry, as used under section 319 CRPC. The court therefore should be understood to have power to proceed against any person after summoning him on the basis of any material as brought forth before it. The duty and obligation of the court becomes more on us to invoke such powers cautiously on such material after evidence has been read during the trial. Then evidence given is the cross-examination. Can we go to next page, page 134, paragraph 98. This is the mere degree of satisfaction the lordships are laid out. Section 319 CRPC empowers the court to proceed against other persons who appear to be guilty of offence, though not an appeal before the court. The word appear means clear to the comprehension or a phrase near to, if not synonymous with the proof. It imparts a lesser degree of probability than proof. There are 95 minutes. Relevant sentence area. At the time of taking judgment, the court has proceeded as a prima facie case is made out to proceed against the accused. Under 319 CRPC, though the test of prima facie case is the same, the degree of satisfaction that is required is much stricter. This is the finding given by the 5 judges. Then my lords will kindly go to 104 minutes. Para 104. In Palaniswamy Governor versus State, this court deprecated the practice of invoking the power under 319 CRPC just to conduct a fishing inquiry, as in the case the trial court exercised the power just to find out the real truth, though there was no valid ground to proceed against the person summoned by the court. Power under section 319 is discretionary and an extraordinary power. It is to be exercised sparingly and only in those cases where the circumstances of the case so warrant. It is not to be exercised because the magistrate or the session judge is of the opinion that some other person may also be guilty of something that offence. Only where strong and cogent evidence occurs against a person from the evidence read before the court, that such powers should be exercised and not in a casual and cavalier manner. Thus, we hold that though only a prima facie is to be established from the evidence read before the court, not necessarily tested on the angle of cross-examination, it requires much stronger evidence than more probability and its complexity. The test that has to be applied is one which is more than prima facie case as exercised at the time of framing the charge, but short of satisfaction to an extent of that evidence, it goes unrebutted, would lead to conviction. In the absence of such satisfaction, the court should refrain from exercising power under section 319 319 CRPC, the purpose of proving it, it appears from the evidence that any person not being accused has committed number is clear from the words for which such person could be tried along with the other accused. The words used are not for which such person could be convicted. Therefore, there is therefore no scope for the court acting under 319 to form any opinion and to give the. Now, the Honorable Judge, leaving all other paragraphs, extracted this last sentence. The finding of the court is that it requires much stronger evidence than mere probability. The Honorable Judge extracts last sentence. So, I need not delve upon whether he is guilty or not. Not the question of guilty, but the material should be mirrored. The satisfaction should be more than a prima facie case. Then mirrored more than framing up a charge. But this is the ratio only mirrored page 1 from para 117 mirror. The lordships of raised mirror. Frame the questions and answers mirror.
Para which para?
Para 117. From 117. Mirror. First one is what is the stage at which power of 319 can be booked? The word evidence used in that I already let you losses. You losses will go to next page, question 4 minutes. What is the nature of the satisfaction required to invoke the power under 319 to arraign an accused? Whether the power under 319(1) can be exercised only if the court is satisfied with the accused summon will in all likelihood be convicted. Though under 319 TSHC, the accused subsequently is to be treated as if he had been accused. Then the court initially took cognizance of offense. The degree of satisfaction that will be required for summoning an accused under 319 would be the same as of framing a charge. The difference in the degree of satisfaction for summoning the original accused and the subsequent accused is on account of the fact that the trial may have already commenced against the original accused, and it is in the course of such trial that material are disclosed against the newly summoned accused. Fresh summoning and appeal will result in delay of the case, therefore, degree of satisfaction for summoning the accused, original or subsequent, has to be different. Does the power under 319 extend to persons not named in the affair, named in the affair but not charged? A person not named in the affair. A person though named in the affair but not been charged sheeted. A person who had been discharged can be summoned under 319 provided from the evidence it appears that such person can be tried along with the accused already facing trial. However, so far as an accused who has been discharged is concerned, the requirement of 300 398 has to be compared with before it can be. That they were accused or not, that is immaterial. This last sentence mirrors whether after discharge, whether a person can be again renamed as accused, once a person is discharged. During course of evidence, again evidence is adduced. Whether he can be made accused, matter was referred to 5 judges again. Their lordships affirmatively said that he can be made accused. A discharged person can also be made an accused. That is the law mirror test. This judgment finally covers the issue. The satisfaction was not reached by the learnership. Hence, absolutely there is no material on record merit to remove the TNHC in the chain. But the same principle following this judgment, several judgments are come. The one judgment is the knocking. I just give the citations.
On what point?
Let's say
What is the principle?
4 judgments are new. There is no need to later. 2009, I'm sorry, 2019 6SCC 638.
6 to 9.
2019
6SCC.
38 minutes. This is the judgment of minutes, Justice, Chief Justice, and then Justice Santhan Gombe. Then 2019 4 SCC 342.
This is also on 319.
Yes. Then we have 2017, we give compilation here. For your lordship, para numbers, only one judgment I passed on. 2017, 7 SCC, page 706. This is very similar to the facts of this case. Here, the person was there in the FIR, then his name was deleted in the charge sheet. In the evidence period, again, the names were spoken to. This under SCST Act claims, SCST attends to Prevention of Atrocities Act. There are 5 hospital claims. They were already made, they were FIR accused. There are 5. Throughout the time of allegation, the police kept investigation ready. Subsequently, it came to the conclusion that the appellants were not involved, and the final report of closure of the case against the appellant was filed. The trial court framed the charges against the opposite 3 accused persons and claim proceeded, though it has been delayed abnormally for more than 15 years. Be that as it may, the prosecution examined 23 witnesses, including PW 1, 2, 3, 4, 5 in year 2009. On 26/4/2014, after 5 years of examination of opposite witnesses, the complaint filed application of 319 CRPC. It is application which has been allowed by the special court. Same similar set of facts, after 5 years they filed application. Then the learned judges extracted material that was produced. Then there are 9 minutes. Where the again was referred to Habib C. There are 10 minutes was this is the findings of 10 minutes. There are 10 minutes. It also goes without saying that P19 is not being considered imposing a take of pressure for proceeding with 20%. Not being an accused can be accessed at any time after the charge sheet is filed and before the pronouncement of judgments, except during the stage of 207, 208, the committal, which is only TSHC. In Hardeep Singh, the Constitutional Bench has settled the controversy on the issue of whether the word evidence that I have already brought to your notice. Then, for the moot question whether there, however, is the degree of satisfaction that is required for invoking the powers of 390 and the related potential situation, this power should be exercised in respect of person named in the FIR but not charge sheeted. These 2 aspects were also specifically dealt with by the Constitutional Bench in Hardeep Singh. 10 minutes. After referring to Hardeep Singh's para 138, 135 to 138, 95, 105, 106, which are read to your lordships. The stage at the time of taking consent, the court has to see that the prima facie case is made out of proceeding against the accused. Under 319, those who test is prima facie case is the same. The degree of satisfaction that is required is much more stricter. I mean, entire thing, what I have read, the lordships are extracted. Then there are 14 minutes. When we translate the opportunity principle with their application to the facts of the case, we gather the impression that the trial court acted in a casual and cavalier manner in passing the summoning order against the appellant. The appellants were named in the FIR. Investigation was carried out by the police on the basis of the material collected during investigation, which has been referred to as above. The IO found that these appellants were in Jaipur with the incident took place at the distance of 175 kilometers. The complaint and others who supported the version of the affair regarding the alleged presence of the place of incident had also made statement on 161. Notwithstanding, then the police investigation revealed the statement of these persons regarding the presence of occurrence at the place of occurrence was doubtful and did not inspire confidence in few of the documented other words. 10 minutes. The record was before the trial court. Notwithstanding the thing, the trial court went by the depositions of complaint and some other persons in their examination chief with no other material. This is Russian state with no other material to support their so-called verbal popular version. Thus, the evidence recorded during the trial was nothing more than the statements which were already there under 161 CRPC recorded at the time of investigation. No doubt the trial court would be competent to exercise its power again on the basis of such statements recorded before its examination chief. However, in a case like present, where the plethora evidence was collected by the IGO during investigation, which suggests otherwise, the trial court was at least duty bound to look into the same, which by forming the opinion and to see that as to whether much stronger evidence than the possibility of their complicity has come on record, there is no satisfaction of this nature. Even if you presume that the trial court was not apprised of the fact that the time with the found order, what is more troubling is even when the matter material in record was specifically brought to the notice of the High Court in the revision petition filed with the appellant. The High Court too blissfully ignored the said material, except introducing a discussion contained in the order of the High Court and expressing agreement therewith. Nothing has been squarely mirrored. The facts of the case squarely covers this.
So there is no subject to satisfaction.
Yes. That's the ultimate criteria. Is it is a matter of and 390, they should be subject to satisfaction application of merit, and representative should come to the conclusion that this material is sufficient prima facie to come to the conclusion is likely to be convicted. When PW's 1 to 3 minutes have explained why these people's name are mentioned in the FIR, they can't again come and depose against this person. We had only these 5 minutes of subject. We had only 216 minutes.
Which is judgment?
2016 6 SCC, page 105.
2016 6 SCC.
6 SCC, page 105. Let's para. Para 18 minutes. Only minute you are so very well aware of 16 minutes. Any stage minute charges can be altered, but the principal minute. Para 18 minutes. From the offer set, it is graphic that the court can change or alter the stage if there is a defect or something is developed. The test is it must be bounded on the material available on the record. It can be on the basis of the complaint in the FIR or accompanying documents or the material brought to the record during the course of time. It can also be done at any time before pronouncement of judgment. It is not necessary to approach each and every circumstance. Suffice to say, the court has not framed a charge despite material on record. It has the jurisdiction to add a charge. Similarly, it has authority to alter the charge. The principle that has to be kept in mind is that the charge so framed by the magistrate is in accordance with the material produced before him, or if subsequent evidence comes on record. It is not to be understood that unless evidence has been let in, charges already framed cannot be altered. For this, not purpose of purport of 216. That each time minute can be altered, but the question is minute. The apex court tells me that there should be material on record minute to show minute that for altering the charge, that was minute the earlier minute was not brought to the notice of the court or court has ignored. There is no material minute to charge minute of 304. That's why this is. So far 304B is concerned that but only one judgment. But there are 16 minutes. Not for the minutes. They lots of refer to the provision on the para 10, 304P, 490 and mirror 130B also the presumption under evidence.
Para 10.
Para 10 minutes, they lots of abstracted all the relevant statutory provisions. 304P, 490 because 304B doesn't separately speak to the harassment. Then minute 113B minute is the presumption. There are 25 minutes. Whereas the offence of dowry is defined by the section 305 report, degraded thereafter.
The reading para 10.
Para 10 are the provisions of the The interpretation of section 304B and the 498 came up for consultation. In Bejnath case, the opinion was summed up in para 25 to 54, which are extracted. Whereas the offence of dowry is defined by section 304B, the ingredients thereof are death of woman concerned is by informs bodily injury or other than the normal circumstances. It is within these two are completely ignorant. That seen before her death, she was subjected to cruelty or harassment by her husband or any relative of her husband, or in connection with any demand for dowry. The offence under section 480 of the code is attracted for the offender or relatives if she is subjected to cruelty. The explanation as the cruelty explanation, any willful conduct which is of such nature as the likely to drive women to commit suicide or to cause grave injury or danger of them or health. Harassment of women with such harassment is with the view to coercion or any person related to her to meet in unlawful demand for any property or variable security or as an account of the changes by her, any person related to meet the children. 10 minutes, there are 16 universities. There are 16 minutes. The cruelty or harassment has to be soon before death. It is evidence either the one father of the stated that 2 months after the marriage, her daughter came to the parents' home, stating that the applicant was demanding motorcycle, however she was sent back. Thereafter, she again came and apprised him that the demand of motorcycle was pressed by the applicant. Besides motorcycle, land was also demanded. There is nothing in the statement that any such demand was raised immediately. This will also be seen. Any such demand was raised immediately before the death, as the incident sought to be referred to or quite old. He admitted in his cross-examination the time of funeral that mother-in-law and two brother-in-law were present. However, they were threatened not to lodge the complaint. PW to maternal uncle of the deceased merely stated that at the time of marriage, sufficient dowry was given by the father of the deceased. However, later he heard that the appellant had demanded the motorcycle. Cross-examination admitted that he was living in the distance of about 1 km. No dowry was demanded at the time of marriage of the deceased. He did not state that the deceased ever shared with him about the demand of dowry or any harassment or non-payment of thereof, though he was living close to the maternal. Then we have 21. In the opposite evidence led by the prosecution, none of the witnesses stated about the cruelty or harassment of the deceased by the appellant or any of his family members on account of demand of dowry soon before the death of otherwise. Rather, harassment has not been narrated by anyone. It is only certain oral arguments regarding the demand of motorcycle. The opposite evidence led by the prosecution does not fulfill the prerequisites. They invoke presumption of BIPC or 113 by Indian Evidence Act. Even the ingredients of 498 are not made up out of the same reason. There is no evidence of cruelty and harassment of deceased soon before the death. In 23 years, on the collective appreciation of the evidence led by the prosecution, we have considered you that prerequisites to raise presumption of 304B and 113B of the Evidence Act having not been fulfilled, the conviction was successful. In view of this, the alteration will not be done. There is no evidence to attract 304 and 202 still cannot be invoked. P19 is concerned with this case there is no evidence nor any material which can convince the learned judge to invoke it. In view of this, both the questions may be allowed. Thank you. With respect of the adding the as accused to the case. Whether the court has committed any legal error in allowing the petition. My humble submission is that reason is maintainable when there is a patent legal error. Now,
What is that patent error? Committed by
because if court has no powers, no evidence at all. Where
though the court has power, has it applied its
yes,
mind?
it has applied its mind.
Whether it has come to correct
Applied, it
conclusion?
has added. My friend has learned senior advocate has relied upon the body committed in section 319. It means he must have committed. It is not that meaning he must have committed the offense. But above that, it appears to the court. That means crime of his.
And what about the protest petition?
Protest petition whether
Basing on the investigation done by the police, as he was arraigned as accused in the FIR,
yes.
they have closed regarding
Regarding whether the pros and cons of the protest petition be considered in this revision or while adding the petition, while entertaining the petition under section 319, whether I have not at all filed a protest petition. Assume, your lordship may assume.
If you have not, well, that's a different issue, but this is a case where it was already dismissed.
Humble submission is that even I have not filed the protest petition. Case is going on. The trial court finds that there is evidence to involve the others, that others have committed, the court can take.
So that is a different
What is
issue.
the
If accused is not arraigned as
It will not have
the
any.
person is not arraigned as accused, it's a different aspect. But this is a case where he was arraigned as an accused.
Yes.
And police has investigated and they have closed.
Then the police have filed.
And
Again, the
charge sheet is-
police investigation, the police have not properly investigated and direct the police to conduct fresh inquiry. I have filed the writ petition. In the writ petition, I have alleged that the police have added the paras to the 161 statement, though I have not stated like that. That writ petition is disposed of.
Have you challenged that dismissal of that? I mean,
Disposed of.
Not dismissed, disposed.
Disposed.
Honorable Justice C. Praveen Kumar, that order disposed.
Disposed of.
the merits.
Because if I have any grievance against the police investigation, against the charge sheet filed by the police, I can file protest petition. Now, even I don't know whether protest petition has filed or not, because the party's petition is at West Godavari. Now the case is running in Rangareddy district.
But I think some material was just not read.
My humble submission is that now it can be lifted whether under section 319, by adding the petitioners to the offense, to the case, whether it has committed any error, whether the order is not in it. My friend has argued that as if it is for conviction and it is for acquittal. For example, under section 304B, altered section 304B, whether my friend is contesting the case under section 304B, defending the case under section 304B, or there is no case at all against the petitioners. There are other sections. 498A is there, 306 is there.
Challenge the order for alteration.
My yes,
216.
challenging alteration. My humble submission is that these petitioners have added to the case.
This is one aspect, that is one aspect.
Yes, that
304.
is one aspect. Though they are different aspects, they are interlinked. 498A is there, 306 is there, Dowry Prohibition Act, section 3 and 4 Dowry Prohibition Act are there. Here, even a categorical complaint alleging, attributing allegations against the petitioners and other accusers. The police have conveniently deleted the petitioners before your lordship and filed the charge sheet. And moreover, they have stated in the in 161 statement, as if the petitioner has stated before the police, I have falsely stated. How can one person say, I have falsely attributed allegations? Then why the police have filed? Police have filed. It is not at my instance. My humble submission is that protest petition is a different aspect. Whether I file protest petition or not, whether it is dismissed or not. Now the court, during the course of trial, on the basis of evidence, court has come to a conclusion that the petitioner to be added to the case under section 319.
No, I don't think the court as suo motu has implicated.
Filing the case, petition by
The
the
application has been filed.
prosecution.
Court has come to a
The-
conclusion.
On the petition filed by the prosecution, finally the order may be seen for a moment.
It's 714.
714, here of page 15. This is the impugned order.
Yes. Page 15.
Yes, Your Lordship, add both sides. Counsel for respondent filed requirement. Now, the point for determination is whether the prosecution is entitled to summon Kalpana and Satyanarayana and accused in this case. And page 16, there are 7. Peruse the entire material on the card. The very basis for the case is the complaint. It was marked as exhibit P1. In the complaint stated that his deceased daughter and son-in-law A1 were put of charity at Modi Nagar, and sister of A1 by name Kalpana and her husband Satyanarayana frequently accused and harassed the deceased, stating that to bring amount from her parents. Now this will be 498A and 3 and 4 of dowry provision. Further, Kalpana and her husband and brother-in-law of Kalpana by name Srinivasrao and Gangadhar Rao visited the house of deceased 1 week prior to her death and discussed about an alliance to A1 at Jangareddy Gudem, and they discussed that if deceased died, the property will go to them. Deceased informed the same to the complainant. Further in the complaint, the complainant referred the names of Kalpana and Satyanarayana as accused. On perusal of section 161 CRPC statement, it was recorded by the police that the period 123 falsely stated report inquest Tahsildar that Kalpana and Satyanarayana harassed the deceased and wrote falsely in the fiction that 1 week before death, deceased informed over phone that her husband Jagan's sister Kalpana and her husband Satyanarayana and her brother-in-law discussed to perform the marriage. These portions of 161 statement, I have challenged the investigation done by the police in the restriction. Now, relying on those statements, the learned senior advocate has advanced the argument. My humble submission is that in FIR there are allegations against the petitioners. In the statements made before the court, on depositions given before the court, there are allegations against the petitioners. So the court has rightly taken.
No, but omission also is there.
Provision is 319 is there, empowers.
No, in cross-examination they were asked.
Cross-examination, they will be.
But they denied.
They will given the opportunity.
Once
they were added, they can engage an advocate, they will recall in the petitioner, they can cross-examine on that aspect. It is not like that merely because they were added.
Cross-examination they have denied. It's not true to say that we have stated in the complaint. They have denied the version they have stated earlier in the cross-examination.
In cross-examination,
they have supported the accused, what I mean to say.
In cross-examination, the 161 statement to be shown the witness in the box, and suggestion will be put that in the 161 statement it is there like this, whether it is true or not. What the witness says, yes, it is true. That is for the judge who is conducting the trial, under what circumstances the petitioner has deposed like that. I cannot deny, no, I have stated, but that is not like there. They have not asked that you have stated in the statement that I have falsely stated because of like that. Because I may deny. Section 319, Your Lordship. Power to proceed against other persons appearing to be guilty of the offence, where in the course of any inquiry into or trial of an offence, it appears it has to be, the committed word has to be read with conjunction with it appears. In connection, it appears from the evidence that any person not being the accused has committed. Committed means he is not a guilty. Straight away, the sentence cannot be, conviction cannot be given. Appears. The word prayer in the prayer sentence, prayer line, the word appears has been used. So prima facie, the court has to come to conclusion that it appears that he is also involved in the case. So the summons were issued, they were added, they have ample of opportunity to defend their case. Because the court has not said that they have committed the offense, they cannot be added. My humble submission is that just for my friend relied upon a judgment.
And where is the
For
subject to
319
satisfaction?
319 in 2016 6 SCC.
2016.
2016. No, sorry. 2017. But if there Vijender Singh and others. Vijender Singh and others. Last version, because though in the evidence they have stated before the court, it cannot be proved and they will be treated as if the statement in the under section 161 of CRPC only the Honorable Supreme Court observed and rejected. My humble submission is that it is in respect of the daylight murder at 3 p.m. Kindly, the appellant's hearing 3 in number have been summoned by the Court of Special Judge, which is in session of the trial in respect of FIR number 53 of 2000, wherein charges for the offences under section 147, 148, 149, 323, 448 and 302/149 of IPC. The case is that in the second para of the said judgment, the factual details pertaining to the FIR and registration of the case against other persons as well as filing of the application by the complainant under section 319 CRPC and the orders therein are as under. On the basis of a written complaint, FIR number 53 of 2000 was registered at 10:30 p.m. on 29/4/2000 under section 147 and so and so, as well as under section 3 and 3. In this complaint, the complainant has stated that at about 3 p.m. on 29/4/2000, when he was at his Kedra well making his cattle drink water, certain persons. This is the case. But in a dowry death case, there will be no witnesses. The Honorable Supreme Court categorically observed in several cases of dowry death, the prosecution need not to prove that by witness. If a dowry death was done in a midnight in the house of the, in the bed of the bedroom of the accused, how can a witness say? So the statement made before the court will not be treated as if the statement in this case. That is my contention. Honorable Court is proceeding with the trial against the persons and they will have opportunity to defend the case, prove their innocence. P19, my friend has relied upon the judgment of the Constitutional Bench of the Honorable Court in Hardeep Singh versus State of Punjab, 2014 SCC 92.
Yeah. Yes.
elaborately discussed at page number 117 after para 24, question 1.
Yes.
What is the stage at which power under section 319 CRPC can be exercised? The stage of inquiry and trial upon cognizance being taken of an offence has been considered by a large number of decisions of this court, and that it will be useful to extract the same here and there for proper appreciation of the stage of invoking the powers under section 319 CRPC. To understand the meaning that can be attributed to the words inquiry and trial as used under this section. At page 118, after para 27, 2G, inquiry means every inquiry other than a trial conducted under this code by a magistrate or court.
Yes.
And what is the evidence? At page 126, after para 67, whether the word evidence used in section 319 CRPC has been used in a comprehensive sense and includes the evidence collected during investigation of, or the word evidence is limited to the evidence recorded during trial. At page 128, para 66, the word evidence is used in common parlance in three different senses: as equivalent to relevant, as equivalent to proof, as equivalent to the material, on the basis of which courts come to a conclusion about the existence or non-existence of disputed facts. As equivalent to the material can be, on the basis of which courts come to a conclusion about the existence or non-existence of disputed facts. Though in the definition of word evidence given in section 3 of the Evidence Act, one finds only oral and document evidence. This word is also used in phrases such as best evidence, circumstantial evidence, corroborative evidence, derivative evidence, direct evidence, document evidence, hearsay evidence, indirect evidence, oral evidence, original evidence, presumptive evidence, primary evidence, real evidence, secondary evidence, substantial evidence, testimonial evidence. At page 131, after elaborately discussing the evidence and where the court can exercise powers, at page number 131, it is therefore 131, para 78. It is therefore clear that the evidence in section 319 CRPC means only such evidence as is made before the court in relation to statement and as produced before the court in relation to document. It is only such evidence that will be taken into account by the magistrate or the court to decide whether the power under section 319 CRPC is to be exercised, and not on the basis of material collected during the investigation. In the FIR, there were allegations against the petitioners, and then before the court, they have deposed against them. Court has exercised powers under section 319 and added it to trial. There is no illegality. And last, concluding the judgment at page 141, Here are 117. The Honorable Supreme Court summed up the conclusions as follows. We accordingly sum up our conclusions as follows. What is the state at which power under section 319 CRPC can be exercised? Whether the word evidence used in section 319 CRPC has been used in a comprehensive sense and includes the evidence collected during the investigation, or the word evidence is limited to the evidence recorded during trial. In Dharampal case, the Constitution Bench has already held that after committal, cognizance of an offence can be taken against a person not named as accused, but against whom materials are available from the papers filed by the police after completion of the investigation. Such cognizance can be taken under section 193 CRPC, and the session judge need not wait till evidence under section 319 CRPC becomes available for summoning an additional activity. Section 319 CRPC significantly uses two expressions that have to be taken into account. Inquiry trial. As a trial commences after framing of charge, an inquiry can only be understood to be a pre-trial inquiry. Inquiries under section 200, 201, 202 CRPC and under section 398 CRPC are species of the inquiry contemplated by section 319 CRPC. Materials coming before the court in course of such inquiries can be used for corroboration of the evidence recorded in the court after the trial commences for the exercise of powers under section 319 CRPC, and also to add an accused whose name has been shown in column number 2 of the charge sheet. In view of the above portion, the word evidence in section 319 CRPC has to be broadly understood and not literally, that is, as evidence brought during a trial. Whether the word evidence used in section 319 CRPC could only mean evidence tested in the cross-examination, or the court can exercise the power under the state provision even on the basis of the statement made in examination in chief of witnesses consent. Answer. Considering the fact that under section 319 CRPC, a person against whom material is disclosed is only summoned to face the trial, and is in such an event under section 3194 CRPC, the proceeding against such person is to commence from the stage of taking of cognizance. The court need not wait for the evidence against the accused proposal to be summoned to be tested by cross-examination. What is the nature of the satisfaction required to invoke the power under section 319 CRPC to array an accused? Whether the power under section 3191 CRPC can be exercised only if the court is satisfied that the accused summoned will in all likelihood be convicted. Though under section 3194B CRPC, the accused subsequently implicated is to be treated as if he had been accused when the court initially took cognizance of the offence. The degree of satisfaction that will be required for summoning a person under section 319 CRPC could be the same. Summon as from framing a charge. The difference in the degree of satisfaction for summoning the original accused and subsequent accused is on account of the fact that the trial may have already commenced against the original accused, and it is in the course of such trial the materials are disclosed against the newly summoned accused. Fresh summoning of an accused will result in delay of the trial. Therefore, the degree of satisfaction for summoning the accused, original and subsequent, has to be different. Thus, the power under section 319 CRPC is extended to persons not named in the FIR, or named in the FIR but not charge-sheeted, or who have been discharged. A person not named in the FIR, or a person though named in the FIR but has not been charge-sheeted, or a person who has been discharged can be summoned under section 319 CRPC, provided from the evidence it appears that such person can be tried along with the accused already facing trial. However, insofar as an accused who has been discharged is concerned, the requirement of section 398 CRPC has to be completed before it can be summoned afresh. This is the verdict given by the Honorable Supreme Court and guidelines framed by the Honorable Supreme Court, that court can exercise by taking the evidence deposition before its. In the FIR, their names are there, but they were not charge sheeted. But in the deposition before the Honorable, before the learned second judge, they are spoken about the involvement of the petitioners. So rightly added there is no illegality. Now, whether this evidence certainly be convicted or not, that is not the criteria. Court felt their involvement, come to a conclusion they have involved in the case. Trying, even the other main accused may also be acquitted after conclusion of the trial. But once there are allegations against the other persons, it is fair to add them to the case and give opportunity to them to defend their trial, their case.
And here the police has filed this.
Police has filed. And my humble submission is that regarding with the 304B,
No, regarding this aspect, 319 police has filed. But earlier they have
yes,
closed the
even I
investigation.
made allegations against them. Police in the writ petition. Now, during the course of trial, they have filed a
In
petition.
view of closing that there is no evidence against them, protest petition was filed by the complainant. In view of closing, there is no evidence. Can they file this application?
My humble submission.
Can they file this?
To forget about the fact of the protest petition. Please assume that there is no protest petition at all. Protest petition.
No, but that has been brought.
Protest petition
No,
dismissed.
the council has already.
My humble submission is that even if there is no protest petition, even if there is no order, even if there is an order against me, even if it is dismissed, during the course of the trial, the court can exercise powers under section 319. Because merely because protest petition dismissed now it cannot be said. My evidence cannot be washed away before the court. The protest petition must be before entering into the court, before framing the charges. Now I have come to the witness box. I have stated that their involvement. So the court has taken, despite the result of the protest petition, despite the fact that whether they have filed, I have filed protest petition or not. That is not necessary. That is not at all consent to exercise powers under section 319. That is my submission.
Come to PW1's evidence.
PW1 evidence, the court has come to a conclusion that there are allegations against the petitioners. So they were included. Now, whether on the basis of those allegations, whether they can be convicted or not after giving opportunity to them, after rebuttal evidence or defending the, after cross-examining.
No, but court has come to a conclusion based on what evidence?
My humble submission is that now.
According to you, what evidence was placed?
My humble submission is that London senior advocate now submitted a argument that even though taken that evidence, it cannot be altered in 304. That is against conviction, even 304B are like that. My humble submission in this, whether this court can sit and this is not sufficient to convict before pronouncing the judgment. Whether this court can sit over the sessions court and can pronounce its verdict, that wording is not sufficient to convict this. Right? The court has rightly added and proceeding with the trial, they will have opportunity. That is my humble submission.
No, but according to what is the material placed before the court to
has stated that
summon these?
In the FIR, their names are there. In the deposition before the court, they have stated that involvement of the sister of the A1 and her husband is there.
See the order, what the order is for.
Page 60.
So para 10.
From the document, from the above document, it appears that while lodging complaint, the complainant raised certain accusation against Kalpana and Satyanarayana. But while giving statement before the police, the complainant deviated the stand taken in the complaint. Whereas the complainant, father of the deceased, PW2, mother of the deceased, and PW3, brother of the deceased, while giving evidence, categorically stated that Kalpana and Satyanarayana also harassed the deceased. The counsel for respondent argued in a written argument that the statements of PW 1 to 3 are disproved in the cross-examination. No doubt, these three witnesses admitted in the cross-examination that they did not depose the same at the time of recording their statement by police and MRO inquest. They did not depose the same at the time of recording their statement by police and MRO inquest. When complaint and evidence given before the court revealing the specific overt acts against Kalpana and Satyanarayana, basing on the statement regarded by the police under section 161 CRPC and before MRO, we cannot conclude that the proposed accusers are not guilty. Specifically stated, court has come to a conclusion. 161 statement is not a authenticated document, it has to be proved before the honorable court. So, basing on the statements of the 161, FIR cannot be washed away, statement before the honorable court cannot be washed away. The court has rightly come to a conclusion. What prejudice is caused to them if they were added to the case? They will give opportunity to defend the case. And regarding the section alteration of section 304B, soon before her death, when it has to be decided whether soon before her death she has met the cruelty or not, in the course of the trial. If 304B ingredients, prima facie ingredients, after the marriage within 7 years, if she dies unnatural circumstances, 304B attracts. Admittedly, she died by hanging herself in the in-laws house. So, it is unnatural death. 304B applicable. Soon before her death, whether there was harassment or not, it is during the course of trial. My humble submission, the Honorable Supreme Court held that what is the soon before her death? It is differed by each and every case. And in para 12 of the judgment, reported in 2022 to ALD Criminal 367 SC, only one para you will occupy read.
You have a copy?
Yes, I am forwarding.
Which paragraph?
There are 12 you have occuped from bottom 4 lines. There are 12,
Yes.
bottom 4 lines, left side. Further, you have occuped that.
Yes.
Further, whether such cruelty and harassment was suffered by the deceased soon before her death as to constitute a dowry death. As to the phrase soon before her death, it is well settled that the same ought to be interpreted to mean proximate and to be linked with, but not to be understood to mean immediately prior to death. It is not necessarily that she should have been harassment made immediately prior to death on the same day. 1 week prior there is allegation.
So
Whether that
1
comes-
week also is proximate.
Proximate. Whether that is proximate or not, it is during the course of the trial. On each and every case it differs here. Soon before her death. First criteria is whether she died in unnatural circumstances within a period of 7 years. The defense to the accused is soon before harassment is not there. It is during the course of trial.
Harassment and regard to demand for dowry.
Demand for dowry is not there. Same day it need not be year long if there is occurrence for demand of dowry.
But I
Harassment,
think the
mental
reason
equity.
was some second marriage or something was discussed.
Yes, because if she dies, we perform another marriage of some other lady, so they will give more dowry and more wealth. For that reason, they have arrested her. That is sufficient. There is no illegality. My humble submission is that there is no illegality in the orders of the Honorable Learned Second Judge, and merely because the wording is divide of merits, it cannot be said that there is illegality in the judgment itself. Even in the judgments of this Honorable Supreme Court also, there are the soon before death, instead of soon before death, they have printed as soon after death. So that cannot be looked into your. Okay,
Soon after that, what harassment will be there?
yes, in that judgment only. Not by read, for me read.
In this judgment, it is there.
Yes.
Where is that language?
It is judgment itself. I read somewhere else. That at the same page 374. Indian Penal Code. Just now I read para 12.
Yes.
Above para 12, Act 1870 first line. Act 1872 makes it clear once the prosecution has succeeded in demonstrating that a woman has been subjected to cruelty or harassment or in connection with any demand for dowry soon after her death. Maybe I assume it is soon before her death. My humble submission is that now this honorable court need not to go into the each and every statement and everything, because the session judge then
According to the complaint is sufficient.
sufficient and the statement before the learned session judge is sufficient to add them. Whether they were guilty or not after complaint. There is no illegal. That is my out.
Is there anything to add? Judgment. Demo, yes, sir.
During the statements under 160, under the criminal procedure.
No, according to them, it's only the complaint and the evidence is sufficient. Need not go into the elaborate whatever is deposed before the court.
I am supported by 5 judges bench and several other judgments. It is not the mere evidence before the court. It is the earlier material that was gathered to the investigating agency that also has to be taken into consideration. It is not as if somebody comes and says before the court that cannot because then the judge should advert to the material on the card. Then there was one judgment just for 2 sentences. Maybe in similar circumstances where the statements under 161 minutes.
Yes.
There are 12. We have heard the land counsel for the parties and find the order passed to the High Court is not sustainable. The present case is basically a matrimonial dispute hearing. The husband who is the complainant has leveled allegation against the wife and other family members. Though in the FIR the complaint has mentioned 15 women and 35 men killed by vehicles, but the names of 11 persons were alone disclosed in the FIR. In the statements recorded under 161 of the court, during the course of investigation, the complainant and witness have not disclosed any other name except 11 persons named in the FIR. Thus, the complainant has sought to cast net wide so as to include numerous other persons while moving an application to 319 of the court without there being primary evidence about their role in house trespass or threatening of the witness. This is the law minutes. Law is your 161 statement should be adverted to. Suppose they have not stated anything in 161. What my friend is stated may be correct. FIR name is there. 161 no allegation is there. Evidence minute they make the statement. Then minute there may be justification because your name is in the FIR. It is coming in the evidence. 161, they categorically state we have implicated them falsely. That statement will stand in the record in the conclusion of the trial. And in the cross-examination, they have admitted that. Suppose in the cross-examination they say, we have not made the statements, we have not made the 161 statement, what is the consequence of rush missing? Then what happens? There is no 161 statement of the witness, thereby no allegation can be proved. Can't be Millett both ways. Once you accept that there is a 161 statement, whatever is stated in that, you have to accept. Or you can say, Millett, this is not my 161 statement.
And what is the reason they have filed some writ petitions regarding the statement?
It was filed for the same relief. No, it was filed for the same relief. It was whether dismissed or disposed, whatever. The learned judge directed them to approach the court for filing a protest.
The judgment is filed.
Protest petition was filed. Very interesting.
That is the writ petition.
That the writ petition is filed.
Interesting one day. My learned friend now has shown me the protest petition was dismissed on 2/9/2022. But on the same day, the appeal order was passed. It's very interesting, Millett. Protest petition which was pending before the court till 2022, it was dismissed for non-prosecution on the same day. The reason is, when there is a protest petition pending, can you take up 319 minutes? Until protest petition is disposed of, we can't even commence the evidence. But this is the trick played by the defendant complainant. He says in 161, to recover my gold, to recover my cash.
The order passed in the writ petition to approach the
Couple of the court for filing the protest. Just in watch me page. WP
714.
Page.
No.
45 in the first case.
714.
45 at 60 minutes.
Page 60.
59 minutes. Last 59. Having regard to the material available on record, this court is the opinion that it's not fit case where fresh or zero investigation can be ordered. But since the petition is agreed by the investigating done, he is always at liberty to avail the remedy available under CRPC. CRPC remedy is being protest petition is not there in the act. It's only Bhagwat Singh's case which has come on, it has been interpreted. Otherwise, private complaint they have to file. But private complaint they could have filed. Nothing, nobody can comment. Now, Millett, having stated before the police that we implicated them falsely, now they want to come and give evidence stating that these persons are also committed offence. This is impermissible. Hardeep Singh, only one sentence.
Yes, but according to statements of LW1, I don't know. That's the reason I think they were not arrayed in the charge sheet because of the statement.
No, Millett, they can't come and say that these statements are not recorded. Once they admit that statements are recorded, what will be the contents they can't say no. My submission is having accepted.
So that's what I was saying. Because of the statement, they were not arrayed in the charge sheet. They were deleted. But again, they have filed a petition under 319.
I'm giving an example, but there may be a case. FIR A is shown as accused. Charge sheet without even mentioning anything in the 161 statement, charge sheet's name is deleted. It happens, many cases are there. During the course of evidence, they state that we mentioned his name in the FIR. In the statement, though we have stated before the police his name was not recorded, now we are giving evidence. Those cases, there is justification. Here, 161, they say that he is not, they implicated them. The wording used is not, they implicated them. What more is required?
They themselves have come forward saying that they are not falsely they have said.
Yes.
Then how come police have filed this 319 petition?
That is the learned public prosecutor has filed. It's not investigating officer who filed. He has no control after the trial commences, after the charges are framed. The control is with the learned public prosecutor, not with the police. Their consent is not required. Prior to framing of charge, you
Yes,
want to.
now court has to look into what are the statements, LW1s, what there's whether there is any material to implead or not.
Evaluation of evidence is the duty of the court. While evaluation of evidence, the Hardeep Singh case, the inquiry conducted by the investigating agency is also evidence. That is the finding. So, the evidence on record is evidence before the court.
Statements.
Statements record. You have to refer to both. The Hardeep Singh, that's what my friend also read it. Though section 390 C194 B CRPC has accused, subsequent period is to be detailed as if he had been an accused. when the court initially took on, then the degree of satisfaction that will be required for summoning a person on 319 would be the same as for framing the charge. The difference in the degree of satisfaction for summoning the original accused and the superior accused is account of the fact the same as, it's a completely different satisfaction. My friend cannot say simply, I have given evidence, he should be taken as accused. That's what my friend is arguing. Law is otherwise. Interpretation of this section is otherwise. They said there should be satisfaction. That the satisfaction is higher than the prima facie case or a cognizance taken under 190, and the court should come to the conclusion the material on record is sufficient likely that he would be convicted. For example, we get acquitted only on the ground of omissions and contradictions. I do not trouble you, Lord Sister, only one judgment.
But court has come to a conclusion basing on only the complaint.
Yes.
Para 10.
Then where is the need for 161 minutes? There's 5 minutes, you have to find time. This gentleman, your Lordship, must have gone through. It's a famous Tahsildar thing.
No, 1954. 1954, I think.
59 minutes.
1954. Omissions and contradictions. Yes.
59. Which year?
Omissions and contradictions. Famous
That's the
case.
today minutes followed. Their minute they said 161 statement is only to the benefit of the accused, nobody else.
19.
Next page, headlines.
Yeah, 1959 only.
Yes,
Supreme Court 101.
Next page. The very purpose of 161 minute recording is only for the purpose of the benefit of the accused. I can utilize that at any point of time. Protest petition minute, subject to what other my friends say. If you don't prosecute a protest petition, that means inside the minute, you are not interested to minute and anybody as accused or minute at any other section to the prosecution. Now minute merely because they make 2 statements, 2 persons come and depose before the court, that cannot be a ground minute to again minute implicate this person. But in view of this minutes, both the petitions are allowed minutes. Already minute, husband, father died because of this. That's what my friend is telling. Father died because of this harassment. Mother and son are facing. Sister and brother, they are living at a far off place. This case where the Supreme Court said that far off places person should not be.
All sure. Relatives cannot be roped in.
Verify the protest petition filed or not, so verify the below.
Only one. The written judgment, page 54, there are 40. Order of the Honorable Court.
Page 54.
There are 40.
Yes.
In the instant case,
53, I think.
Yes, sir.
there are 14.
Para 14.
In the instant case, the request of the petition is not for further investigation, but for de novo fresh investigation, meaning thereby that seeks the entire investigation done to be illegal and improper. Had it been a case of further investigation, definitely the judgments referred to the above would have put the recipe of the judgment some or in some form or the other, but situation really is otherwise. Because the petitioner has sought for fresh inquiry stating that this is the inquiry is false. And page number 58, 57, I believe, there are 21. There are 21. The grievance of the petition in para number 5 of the update that is that respondent number 3, that is investigating officer, in collusion with the respondent 4 to 10 to have created false statements and added number of paragraphs to the statements of witness, thereby diluting the case. So, I am disputing the 161 statements. I have filed the retreat petition. The Honorable Court said you file protest petition. Now the prosecution has come with a petition to add the petitioners as evidence is against them, as I have deposed it before the Honorable Court. Now,
No, if evidence is deposed against you,
evidence, my
court has to sumo to add you.
yes.
But this is on application filed by the prosecution.
Prosecution also, if the sumo to, if there is a legal error, court has to take sumo to the regional jurisdiction If the court doesn't take,
Have you filed the protest
we
petition?
can file. We have filed the protest petition. My friend is saying that protest petition has been filed. That was not prosecuted. Dismissed for non-appearance. And by that time only, it seems the police have filed the petition and that was pronounced judgment. Maybe the court below ought to have thought that already there is a petition of the prosecution and dismissed it without giving opportunity to the petitioner.
Shall I tell him to get? Shall I tell him to get instructions on protest petition, or shall I take a submission?
I have practiced in trial court. I can say that 161 statement can be shown to the petitioner whether you have stated in this. These lines are stated by you. It is written by like this. He has to, yes, there is there. It is true that there is a statement in 161 statement. That doesn't mean I am admitting. I cannot say that there is nothing there.
But here he says
that is why my humble submission is that it is for the trial court to decide whether they can be convicted or not. I think there is no legal error.
you can get the protest petition filed, and what is the case status? You can
the protest petition
file written instruction. So shall I take it as heard on the list for?
Without record, I can't.
Because that's the reason I'm asking.
That's what I'm saying. My instructions I'm saying without any record.
Let him get that regarding the protest.
With great respect to my friend. When you are contradicting the investigation, option available to you is go for de-novo inquiry, what they have done. Alternatively, private company. But when you are zoning the statements, the only remedy is private company. When you have not filed private company, and you have not pursued the protest petition, presumably the statements recorded by the investigating agents are correct. And the cross-examination they have not denied. Question is where the contention cannot be the evidence. The evidence is been recorded by the court. Had they said one sentence in the court my statements were not recorded properly. No. Let my contention show that it is before the court, what is stated is evidence. Not if my friend may not prepare a compilation with paragraphs, we will submit your office.
Okay. Shall I list it under the caption for orders and let him get regarding the protest petition, and you can give a compilation.
Okay.
When shall I list? Shall I say Tuesday? Shall I say Tuesday or Friday? I think it's not possible for you. Diwali and all. When should I date? Next Thursday? Next Thursday. I'll put it on Friday because Thursday I'm not there. 17th. Request of Assistant Public Prosecutor. Captain regarding the status of the protest petition.
Extension minutes. Judgment is pronounced. What is the matter?
Milan, so sitting there.
The Lordship's permission.
Today they are expelled. Not modest.
30.
Just 11 వరకు
Expiring on 21st. And before that we are listing on 17th hour. Not required.
I'm not there, the presence is required, but that will be there.
No, I think after taking the instructions, I will reserve it on that day.
Yeah, some convince I will not be there.
No, not required.
It is required clarification.
Okay.
Yes. With your Lordship's permission.
2014 sessions case made. Will be the result, just disclose the investigation. And the your Lordship pronouns are there. Trend is insisting for the past 8 years we are suffering in the parties.
I didn't understand. So what is that?
The expeditious disposal of the child.
For the second matter.
Both. Yes, second matter.
Second.
We'll see.
I'll just say expeditiously because I think time fixing time bond.
3 passes. 3 matters are passed. Passed over.
Tomorrow we'll take up some passwords. Take up tomorrow.
Item number 44 marks. Taken up tomorrow.
44. You're ready?
Material papers are not been served.
Not served. Okay, file papers will take up on 22nd.
Item.
22nd, 11.
May I say this?
Yes, yes.
On 18, it is coming for defense evidence. On 18, it is coming for defense evidence. My
18th you are having court.
18.
Saturday.
Yes, at the 8th MM, what have been instructed is, say, 8th MM is taking up matters on Saturday, as far as mine says. The prayer would have survived. It's not heard before. That's why
17th, shall I list? 17th. 17th.
well, it's on top of the list, if my mail.
First, kindly, item number 57, the orders are expiring today.
57. Mention of increment.
39 party.
5th December. Extended. List on 5th December, extended.
With your lordship's permission.
Just a minute, just. 39 and 40. Expiring today.
Yes.
Today.
Yes.
Same orders. Extended till 13th December.
Lordship item 58.
39 ఒక్కదాంట్లోనే ఉన్నాయి ఆర్డర్స్ 40లో లేవు
Only in 39 items, sir.
So 39 and 40 connected.
బట్ ఒక్కదాంట్లో
But orders are only in 39.
39 party also order there. Same order only.
Yes, verified. Okay, subject to verification. 13th December. Extended and list on 13th December.
Lordship item 58.
58.
In this matter, it is coming for finally. In this matter also, interim order is made case to and even I informed to other response council, Lordship, I can by some date and extend the interim orders.
Okay. And under the same caption.
Yes, ma'am.
Okay, December 27th.
27
December extended. List on December 3rd. Yes.
Well, that's item 48, 51, and 54.
48
51 and 54. Malats, I have filed extension petition IA number 7 of 23. Malats, Lordship may kindly extend the interim orders. Malats.
Item 53 also in that attachment representing G. Rajeshwar Reddy. We have also filed extension.
53. Extended till 29th December.
Highly obliged.
And list on 29th December.
So one submission, item 44 may be taken up on 16 minutes. The difficulty is with the bank.
16th, I'm only, that's the reason I'm telling you. Otherwise, I could have listed on 16 and kept quiet.
And make a mention.
When? On 17th.